Did you miss me? Feels like forever ago, that one extra day difference. Feels like it's been like a month. Hopefully you got some studying done this weekend. I got you, Samantha. That's fine. It registers your time, so you're okay. We are in the middle of contracts. We finished 9 last week. We'll do a little bit of review on that. And then we're going to get on into chapter 10, which is called Sales Contracts and Related Procedures. We're going to get more specific about what we deal with in North Carolina. So that's what it's about. If you haven't yet, put your name in the chat for me. And one more thing, I want to make sure that I rename my other login so you don't chat to me. That's one. There we go. The one that says co-host. I'm not sure if you can see it, if it shows up as co-host to you. But that's just my observation one, so I can see you in my little teleprompter while I'm looking, hopefully, into the camera lens. Because that's what Zoom is all about, is getting that connection. It's easy to not have it because everybody looks away from you. Here's what a syllabus looks like. Don't forget, this is your best friend. Hopefully you've been using this every time you read anything. This should be your guide, right? That big monster 800-page book, all of it is not necessary. Which part is? The stuff referenced here, right? In the syllabus. So I'm hoping by now your syllabus is looking pretty messy, pretty colorful, marked up in the margins, highlighted, so that you're making yourself a review item, like a tool for review. And this, let's see. Yeah, this is a great example of a place where you can fill in the blank, right? You can actually write in the definition, print this thing off, put pen to paper. There's actual proven studies that you learn better when you write things out. So write it out. Certainly easier and faster and neater to type it, but it's just something about writing it. And again, make notes, cross-reference, turn this syllabus into a cross-reference with your textbook. What page in the book are we talking about here? Write that there so you can flip over to it. Pretty easy. So this is what we covered in chapter 9. That was just the basics. Forgive me. I have contact issues. So I'm going to be sounding like I'm sad, but I'm not. And we'll go through a review here in the slides in just a moment, but just a lot of terms here for you to fill in. And again, just turn this into a device for your review time. Okay, that brings us up to chapter 10. Let's take a look first at some chapter 9 stuff. And let's do it in the form of a poll question. So, there we are. Oh boy. Bear with me one moment. Doesn't want me to do a poll session. It's okay. We'll do it with the slides. I'll figure that out at the break. So if you remember in chapter 9, it was all about contracts and just the basic law. What we covered in chapter 9 is going to be the kind of thing that could show up on the national portion of the exam. There we go. And keep that in mind. Chapter 10 is going to be a lot of state portion of the exam because it's going to be specific to North Carolina. But 9, as we do a little quick refresh, we just got into some basic definitions. If we look back at the syllabus real quick, there we are again. One thing to keep in mind and remember to do, observe the levels, right? The levels are important. They're there for a reason. What do the levels mean again? If it's level 1, strictly just definition. Don't spend any more time on it than just understanding kind of what it is. If it's level 2, a little more than that, right? Having some understanding, some ability to compare and contrast. And level 3 is the biggest, the most involved level that we deal with. So what do we have here? Level 2. And then a lot of times they'll say, well, everything's level 2 except this particular one. So you don't have to go to level 2 with bilateral and unilateral. Just know that bilateral means 2 parties have made promises, and unilateral means 1 party has made a promise. If you recall, let me know if you remember, what is an example of a unilateral contract? It's a good example of a kind of a sales contract or a sale that we deal with that it would be only 1 party making promises. One party has to sit back and wait for the other one to make a decision. There's a hint for you. What's an example? That's a unilateral contract. And yeah, perfect, Yvonne. Option to purchase. An option to purchase, the seller can't do anything except sit and wait for the buyer to decide what they want to do. Because they, for exchange of money, gave the buyer that privilege. Okay, buyer, sure thing. If you want to wait and decide later if you actually want to buy it, okay, fine. Give me the money. All right, $5,000, $10,000, whatever the option fee might be. I'll sit back. I won't sell my property to anyone else. I'll wait and see what you want to do with it, if you even want to buy it. So that's an example of a unilateral contract. That's the sort of thing I've seen on practice exams. And essentially bilateral, unilateral, that's level 1. There's a lot of level 2 in this chapter 9. The essential elements of a contract are level 2, unless they tell you more. They go into more of a deep dive with mutual assent. We'll cover that in just a second. We'll recover it in just a second. But I just want you to remember to pay attention to this. It will help you save time, right? Why spend level 3 kind of time on something that's only going to be tested at the level 1, right? Requirement for reality of consent. Oh, there's a level 1. Just basic contract law with regard to auctioning. What do you need to know there? Just that the auctioneer has to have both a broker license and an auctioneer's license. That they are an agent of the seller, because that's basically they're a listing agent. They're just choosing to use that specific method of getting it sold, the method of auctioning. They also need to have did I say this? An auctioneer's license along with the broker's license. But the person who is saying it, the one who's conducting the auction, talking really fast, that's called the crier, and they do not have to have a real estate license. These are all easy points and very realistic potential test questions. Does the crier have to have a real estate license? They're not going to ask you yes or no, but they might say, which of the following does not have to have a real estate license? And the crier of an auction might be one of those answer choices. And it would be the answer because they don't need one. So level 2, just make this a practice when you go down through the next syllabus chapter that you're ever reading and getting ready for. Just do a quick scan and think, what am I expected here? What am I expected to cover it? In what depth? Because here's the other thing. We're in the middle of the big monster chapters. Now, 10 is like a 7-hour chapter. So we're going to be spending all night tonight and most of tomorrow night on this chapter as per the syllabus. And then what comes next? Another big one, finance. Finances syllabus section 11, which in your book happens to be chapters 14 and 15. So if you don't have this or can't remember where this is, it's in the Google Drive. This is your study guide. What comes next is the closing procedures. And while there aren't a ton of questions for as far as procedures go, as we find out here in the Relink book, we're doing some cross promotion here tonight. Hopefully you know all your resources. Closing a sales transaction. Look at that. One question on the national, one question on the state. However, closing math is some of the most extensive math you're going to be doing. So if we flip on over here to the mathematics section, then 8 calculation-related questions on the national portion of the exam, and a lot of those are going to be from the closing math section. Things like, how do we prorate for property tax? You know, when you close your house in a given year, you're the seller and you owe from January 1st to that day of closing. And the buyer's going to have to make up the rest of the year. So it depends on when in the year you close. There's 3 possibilities. That and just a whole bunch of other stuff that we'll get into. Don't be afraid, you math phobes. It's okay. I've got some guides and systems and techniques to help you overcome that. Any sort of reservation you might have. But here's what I was getting around to. After property valuation, so like 3 syllabus sections from now, we get into the little onesie, twosie kind of chapters, right? Little 1 hour, 2 hour chapters. Landlord, tenant, and property management are the biggest ones. But then fair housing is relatively short. Taxation is pretty short. Construction is probably the shortest. And so looking in your syllabus, you'll find that pretty much the entire chapter about construction is level 1. Just know what some words mean. So pay attention to those levels. It'll benefit you. Okay. So we got into these 2 words, and express versus implied. Express versus implied, meaning easily testable related to this is, what is an express contract? Does it mean it's in writing, or does it mean it's verbal, oral, or is it neither, or is it both? You can tell me that in the chat. What does express mean? Oral, written, both, neither? Sometimes the answer is right there before you, and that's okay, because we're hitting all the cylinders here. We're hitting the visual, we're hitting the audio, and we're hitting the tactile, which means taking notes. So it's all good. That's what review's all about. Here's our unilateral and bilateral, 1 promise versus 2. Here's another one, executory versus executed. Which type of contract, executory or executed, is the one when you are under contract? You're under contract. What do we call the contract while you're in the under contract period of time? We're under contract. We're not finished. We're far from finished. We have lots and lots of things that could make this transaction fall apart. Inspections, appraisal, survey, encroachments, title search. And so, since we're not finished, think about it this way. You can remember it this way. If you remember verbs, right? What are past tense verbs? We walked yesterday. Ends in ed, right? We walked yesterday. So executed means we're finished. That's past tense. We're done. It's over. So executed is not the one for during your under contract period. Executed contract is the thing that we call it while we are in the contract period. Sorry, when we're done. Executed means is what we call it when we're done. So if we look at it like this, here's our closing day. Here's our under contract moment in time, right? When everybody signed everything. Here's our due diligence period right there. But this entire time, we call that contract executory. It's only when the deed is recorded and therefore the transaction is officially closed, that we can call it executed. So just think of it maybe in those last two letters, because that's past tense. We're done. It's all finished. I look like I have a sunburn. Gotta get that color adjustment. Okay. Here, this is another problem area that people takes a little time to grasp these concepts here. The V words, right? Valid, void, and voidable. Valid, void, and voidable. What does valid mean? Give me some idea of what do I mean when I say the word valid in terms of a contract. A valid contract. What comes to mind? That's good. I like that. Good on both sides. Yep. How about enforceability? How could we use the word enforceable when it comes to describing this valid contract phase that we're in? If it's a valid contract. That's good, Holly. Yep. Legal ability to perform, mentally competent. Yeah, valid is enforced. There it is. That's what I was looking for. Enforceable on both sides. If either party tries to back out, breach, not go through with it, then in a valid contract, the other party has some remedy available to them. They can take them to court over it. They can enforce the contract. That's what valid, that's all it means. It doesn't mean that one's good and one's bad, one counts, one doesn't. The question when it comes to the V words is, who can back out without consequences? Who can back out without consequences? And so for a valid contract, neither of them can back out without suffering consequences because they both have obligations and have remedies available to them for the other one performing. So both of them have to perform or else, right? Or else something, right? Void, how many of them could walk away without consequences when it's a void contract? Which of them can walk away without any consequences? You got it. There you go. Both of them are free to walk away, and there's nothing the other can do. It's not enforceable. Take it to court. Try it. Judge Judy will kick you out. Get out of my courtroom. Show it to me in writing. Oh, you can't? Then get out. Right? Not going to work. And then finally, how many of them can back out without consequences when we're talking about avoidable contract? There it is. So if the question is how many can back out without consequences, then the answer for valid means neither. The answer for void means both. And the answer for voidable is, as you've said, one. In a voidable contract, one of the parties can back out without consequences. It's enforceable only upon the other one. Give me an example of that person who can back out without consequences. What is it about them that makes that possible? You got it. Minor, that's one. Underage, not 18. Under the influence, sure. Mentally sound, there you go. You're done. Good job. Mentally competent, 18, sane, and sober, right? That's the quick, easy way to say through those three. 18, sane, and sober. Now, if you recall, though, we talked about a little nuance between void and voidable and the mentally unstable category. If a person has been medically determined to maybe have Alzheimer's or dementia, then they sign a contract. Which word describes that contract, void or voidable? If they have just been medically determined to be incapable of handling their own affairs. It fits right in with that legal ability to perform, legal capacity to perform, yeah. 18, sane, sober, the sane one, it's voidable. However, if we have escalated this thing and it has gone to court in a court of law, a judge, a court of law has said this person has to be looked after. They can't handle any of their own legal affairs. And then that's what's happened. And now that person enters into a contract. What do we call that contract? Because of the judge's ruling, court's ruling that they need someone else taking care of them, then yes, you got it void. Think about it this way. What else do we say about void contracts? Either party can walk away without consequences. So the legal component makes it so that either of them could walk away instead of just the one who is not legally, mentally capable. But over all of those, with regard to all of that stuff, regardless of all of that stuff, the parties could still show up at closing, sign the papers, give up the money, sign over the deed, and have a successful closing. Could still be honored, could still close, even though all along the way for the void and voidable one, someone could have walked away. Maybe both, maybe just one, depending on void or voidable. But it was unenforceable, but it could have still been honored, still been closed. Something else we talked about was these words. Addenda are things we attach to offers to purchase. If we're just making an offer, we don't have a contract yet. Big difference in rights and privileges and what we can do and can't do between when we're just in the offer stage and when we're in the contract stage. Right now, for my property, we have signed it. Me and my brother and our wives have signed the contract. However, what we signed did not have the seller's signature yet. We signed it, sent it over to them, and as of now, we do not have it back. I've not been communicated with, and so if they decide to walk away, I could try to take them to court, but it'd be a waste of time and money because the judge would say, show me the contract signed by you both, and I would say, well, I don't have that. I have the one just signed by us, not them. Get out of my courtroom. Right? I've got nothing. And so if you're my broker, you want to put some pressure on the other broker and try to get that thing back signed, because here I am, a seller, just waiting, impatiently waiting to get this thing locked down so that I can now be considered executory contract, now be considered off the market and officially under contract. So the way that applies to you is get these things in writing ASAP and be nervous until that happens because you got nothing. Yeah, but they said, but can you show it? Do you have it? So we'll get into that offer and acceptance thing a little bit more tonight. It comes back to this word. And remember, this is level 3. This is level 3 because making an offer and having that offer accepted includes another term that makes all the difference in whether this thing is real and truly under contract. So here's a situation. Buyer, seller. Got our buyer agent, got our listing agent. Here's our fence down the middle. They write up the offer to purchase. The buyer signs it. They send it over to the listing agent. She sends it up to the seller. The seller says, you did great. Perfect. Exactly what I wanted. Signing. I'm signing it. And that seller tells the listing agent, we're done. I'm signing it. We're under contract. Listing agent says, oh, great. Thanks. Okay, I'll let them know. At this point in time, the seller has communicated to their listing agent that they have signed and accepted the contract. But are we under contract? Look at all those shaking heads. Look at you guys. You're so smart. That listing agent needs to do what? Tell that buyer agent. Communicate to them. The contract could still be over here in their possession, signed by the seller, but not yet sent over. But the communication is the key. We had an offer, we had an acceptance, but that doesn't mean it's a contract yet until the communication has happened. And so then the other nuance was telling the buyer agent is one thing, but what if that buyer, back when they started working with that agent, said, nope, I like you, but I don't like you that much. I'm not going to let you be my buyer agent, but I'll let you represent me as the other thing. the one we don't like, sub-agent to seller, if that's their relationship, then when this listing agent tells the sub-agent to seller, do we have a contract? Love it. Love it. Until that sub-agent to seller tells the buyer, at that point, yes, now we have that crucial moment of communication that makes this thing under contract, makes this thing executory. So they like to give you examples and little paragraphs of, for instance, broker Betty made an offer on behalf of her buyer, Ed, and sent it over to the listing agent. Listing agent shared it with their seller, Sally. Sally signed it unchanged and told the listing agent that they signed it. Listing agent then, this was at 6 o'clock. Then at 7 o'clock, the listing agent told the buyer agent that it had been signed. Then at 8 o'clock, the buyer agent told the buyer that it had been signed and accepted. At which point in the timeline did this become under contract, or did this become executory? That's the sort of thing they'll do. So be able to go back, which time? 7 o'clock when the offer was sent over, 8 o'clock when the offer was sent to the seller, 9 o'clock when the seller signed it and sent it back notification to their listing agent. That sort of thing is what we're after. Now, there are a couple of things that can happen when they make that offer. What are the possible ways a seller could react, or an offeree could react when they receive an offer? What could they do? They could accept it, or they could do what? Sure thing. They could, that seller, or I don't want to always say the seller, because the offeree could be either one, right? The offeror, typically the offeror is the one who makes the offer, and usually it's the buyer. But the moment that seller counteroffers, now they are the offeror, because they're the one presenting an offer, making an offer. The one who's making an offer is not always the buyer. Could be the seller. So pay attention to that in the test question. Let me see. Yes, I think if you're asking this, I see this, a direct message in the chat. To clarify, it's when the buyer agent gets the offer. Yeah, it's when that communication is from the listing agent to the buyer's agent. That is the communication necessary for this thing to be considered a contract, under contract. Or if the buyer is represented not by a buyer agent, but by a sub-agent to seller, then telling that sub-agent is not enough. It's only official until the buyer has been told. So the difference between buyer agent versus sub-agent with regard to communication. Okay, so the one receiving the offer, probably the seller, but it could be either, has a choice. Could accept, could reject, could counter, and I guess officially they could ignore it. That doesn't accomplish much. And sometimes they ignore it because they're offended at how low it came in. I got one of those letters today on my property that I'm pretty confident is going to sell. A whole nother, gosh, what's the name of them? I think they're called, I don't know, like Whole Lot of Land LLC, some outfit out of Indian Trail, sent me a letter and said there's a 1-page contract attached to this letter. No, I think I left it upstairs. And they're offering me a ridiculous, like pennies, like 2 pennies on the dollar for my property. And they're just throwing that out there. They're casting a net. They're trying to find desperate sellers. And they said, it was interesting. They said, here's 3 ways you can handle this. Number 1, take a picture of the signed contract attached. Once you sign it, take a picture and text it to us. Like, okay, well, that's speedy. You could also take a picture and email it to us. And then I forgot what the third one, I think maybe just snail mail. And I couldn't help myself. I've been so good. I've been so non-confrontational and good in the last many, many months. I took a picture of it. I texted it and I said, I hereby completely and wholeheartedly reject this ridiculous offer. And it was just fake. It was a robot, and it responded and they said, thank you for your response. We will address it shortly. And I said, don't bother. And it just made me feel better. I know nobody's going to see it. They're going to throw it away and delete it. But these are the choices that Offery has. And what is it about this counteroffer choice that you need to know? What is a counteroffer? Is it like any of these other things? It's sort of like one of these other things, but it's a little more involved. It's an outright, first of all, rejection. You got it. And a counter proposal. So it's not just a counter, it's a rejection of the original. And so the reason that's important and testable is when that buyer makes that offer. When I write OTP, I mean offer to purchase. Makes that offer, sends it over here. Seller counters. And then maybe the buyer rejects the counter. If the seller were to say, oh, wait, okay, let's just go back to the original one. I'll go ahead and sign it right now. Do we have a contract? What is it about that counter? It's a rejection. It killed it, right? It killed that original one. It's gone. It's off the table. Never to be resuscitated unless the buyer chooses to after the fact. The buyer would have to say, okay, we'll put it back on the table. But just automatically, even though that seller, think about what's happening here. The seller has this thing in writing. They have this offer to purchase with the buyer's signature. And at first they try to counter it because they wanted to make one little change, maybe a date, maybe the price, maybe something silly, maybe something big. And if they sign that, what does this thing not have, this counter offer? It doesn't have the buyer's initials next to that change. Yes, it has the buyer's signature, but the signature was pertaining to the original offer. It just has the buyer's original signature from the original offer. It has the seller's new signature of the counter and also a strike through or a modification with the seller's initials, but the buyer would have to initial that change as well, right? That's one way it could be handled. That's sort of actually the old school way. It's really not handled so much that way anymore. They're not printing this thing off. The way it really works, usually, buyer puts it in writing, the initial offer. Well, the agent has the buyer sign it, sends it over email via DocuSign, .loop, some sort of signing software. Seller takes a look, wants to counter. And if that's the case, the agents will probably go back and forth with email or text or both if they're smart, and say, no, they won't do this, but they will do this. So this original offer sitting right here just has the buyer's signature, and all these changes are being made, but not on the actual paper. They're not like striking through and signing it necessarily and initialing the actual document. They're handling it with email back and forth till they get it all worked out. Might be a dozen times. And once everybody decides, yeah, okay, let's do it this way, then somebody, one of the agents, doesn't matter which, is going to draw it up nice and fresh. Just the way the most recent version went down. Then they're going to get signatures from everybody. And that's really more of the procedure that the Real Estate Commission the thing about it, the Real Estate Commission likes is that it's nice and neat and easy to understand. What you don't want is a bunch of scribble, scrabble, mark throughs and cross outs. And you don't want this kind of a contract to go all the way to the closing table, because inevitably there's going to be questions and we can't tell what was intended. So the commission says, you know what, when you figure it all out, write it up from scratch, make it nice and neat. That's actually a testable item. So you're going to want to neaten it up. So any terms, though, any little change constitutes a counteroffer, a rejection, and a re-proposal. Any terms at all, even one little day closing difference in settlement date. How can an offer to purchase be terminated? How can we terminate an offer to purchase? So step one, when you hear a question or read a question like that, step one, if you hear the word offer or contract, go back and make sure that you got the right word. Make sure you know what they're talking about. In this case, we're talking about the offer, not the contract. So how can an offer be terminated? Expiration. Thank you. I like that one, Marcus. It could expire. It's not going to automatically expire. You would have to include an expiration clause. It doesn't automatically have one, but you can add one. How would you add an expiration to an offer? What would be the name of the document you would use to include an expiration, a ticking clock to your offer? It's an A word. And I'll give you a choice. Is it an amendment or an addendum? Which type of document would change your offer to purchase to include an expiration? Look at you. There you go. Marcus, Joseph, Holly. It's an addendum. You would use an addendum. It's called an additional provisions addendum. And again, that offer doesn't automatically have one in there. You'd have to add it if you want it or if your client wants it. Let me show you what that looks like. There are several addenda, plural of addendum, that we will look at and reference. And here is the one I'm just mentioning. This additional provisions addendum accomplishes several potential goals. And the very first one it can accomplish is if your buyer wants to set up an expiration. And there it is. Hey, we're making you an offer, but this thing expires unless you tell us and communicate to us by this time on this day. And then another little magical phrase that we've heard before. Because if we're setting up a deadline, you better believe that time is of the essence. When does it expire? That's the deadline. So it could say 12 noon on Thursday, March 30th. Tomorrow at noon, this thing expires. So tomorrow at noon and 1 second, is this offer still on the table? It's dead. The offeror, the maker of the offer, chose to kill it. It's like Mission Impossible. You know, the first 10 minutes of those movies, this message will self-destruct. It gives them about 1 minute to read or hear the message, and then it fizzles away. Well, this same effect. So that's an automatic termination, but it's not included unless you attach the additional provisions addendum to the offer to purchase. A couple other things that we'll come back around to this. It accomplishes 6 potential things that are not all needed necessarily. But let me stay on track here. So what's another way that an offer could terminate? Expiration is one. Rejection. Look at that. Good old-fashioned rejection. And what's a close related one to rejection? Ooh, wow. Getting right down to it. Buyer dies. Okay, I hear you. Seller dies. That's one too. Something similar to rejection. Counteroffer. Because that terminates the original offer and makes a whole new one. And then one more that I'm thinking about. What if the buyer says, you know what? We made that offer yesterday. We still haven't found out if they want it to reply or not. But in the meantime, agent, you just sent me a new listing in your automatic search that I'm really interested in, and I think I might want to go see it. and I might like it more than the one we made an offer on. Does that buyer have to wait for the seller to respond, or can that buyer go ahead and look at that house and make an offer on it? You got it. If they're fast enough, they can rescind it. As long as they communicate to the other party, look, I'm out. Forget it. Forget that offer that we made. It's over. We're pulling it. We're backing out because found another one we liked better. You shouldn't have taken so long. You should have been faster. So they like to test you on that sort of thing too. Okay, more terms. When you make an offer, here's how that looks. Making an offer. Of course, we're going to have several pieces of paper. We're going to have the offer to purchase and contract. And if we use the standard version, it's Form 2T. That's the standard one. Who wrote that form, by the way? Who wrote this Form 2T, offer to purchase and contract, that we use? We don't have to use it, but we tend to use it quite often, we being us realtors. So who is it that provides us with this form and all of the other forms? You got it. A version of NAR, it's the North Carolina version, NCAR, and the Bar Association. So it's North Carolina Attorneys and North Carolina Realtor Association that has created all of these forms. And what's cool about these standard forms is they're balanced between the parties. They're fair. They're pretty equal. If, for instance, you buy new construction, that builder is not probably going to use this standard Form 2T. They have had one made from their own attorneys, and it's very lopsided. It favors the builder more than it favors the buyer. So the offer to purchase. What else? What other documents do you think we need? You're the agent. You're my buyer's agent, and I want to write an offer. What forms do you think we need? We've talked about these. I'm not springing new stuff on you. What sort of disclosure, conversation, all that sort of thing? It's a handful of them. What are some other documents you're going to need to have ready for me to sign? There it is. Probably a residential property disclosure. We'll just say disclosures, because RPODs, MOG, mineral oil and gas, maybe lead-based paint. When would it be a lead-based paint disclosure needed? There you go. If it's built before 78, when would an RPODs disclosure not be needed? There are about 12 or 13 cases, but the most frequent ones that we run into and that I would foresee that you might be tested on, you got it for new construction. New construction not required to have a residential property disclosure because everything is new, right? Or foreclosure. That's another one. My favorite one has this crazy word sanguination in it. Sanguination basically means blood. So blood relatives. There's some other things like married people getting divorced and one of them gets the house. You don't need the disclosure because you both were the owner. Now only one of you is the owner. If you decide you don't want to provide it and they are cool with that, the parties could agree not to do it, not to use it. What about a for sale by owner? Does a for sale by owner have to provide the residential property disclosure? For sale by owner, no agent in sight. No agent involved. They're selling to an unrepresented buyer. No agents necessary. You bet. Good job. Still need it. Unless it's one of these other things. And there's about, again, 12 or 13. It's mentioned on the RPODs, shows you the general statute where you can go find those other 12 or 13 things. But even a for sale by owner has to provide it. By the way, remember up here, I said the 2T and all those forms of addenda and amendments are provided by the Realtor Association of North Carolina as well as the bar. Here's some exceptions. The RPODS, Residential Property and Owners Association disclosure statement. The MOG, let me think, are written by the Real Estate Commission. You get that from the Real Estate Commission, or at least the RPODS. Definitely the RPODS. I'm going to have to double check the MOG. But the RPODS comes from the commission. It doesn't fall under these, but we still need to provide it in most cases. Okay, keep going. What other documents do we need to have them sign? I'm going to make it look weird so I can have some more space here. We had offer to purchase. We had the disclosures. What about who you represent? What do you think you need to help make sure everybody understands who's representing who? There you go. Working with real estate agents disclosure. That is your proof that you explain to your client how this whole thing works, but does that actually hire you? So what's the next thing you need? You've explained about agency. Now you need to do is set up agency. And depending on what your role is, you're going to need a buyer agency agreement or a listing agreement. And depending on what other terms they might want to include. Or in one case, I'm thinking about maybe special kind of financing they're going to get. You would incorporate various addenda. The additional provisions one for an expiration, an FHA VA financing addendum. We'll go into all that a little bit later. Oh, okay. And then back on track. We got the paperwork we need. Now what else? What else do we need? We got them we filled it all out. Got the buyer's signature on everything. Now we need some money. What money do we need to collect from this buyer? We need two items, two pieces of money, 2 checks, and you got it. Earnest money and due diligence fee. Those 2 things. Now, what would we call these things, these amounts of money? What would be another word for earnest money? So hugely open-ended questions. Thank goodness you're not going to have to do those on the test. You get multiple choices. But what's another what does earnest money do? Just tell me what you know about earnest money. Could be what it does, what it's called, another word. It could be where does it live during the under contract. Anything you can think of about earnest money. There you go, Marcus. Yeah. Lives in a trust account, Marcus says, shows seller you're serious. Another word for it is good faith money. It's showing the seller that you are a serious buyer. It's basically telling that seller, look, I'm so strong of a buyer. I'm so confident and I'm serious about this. I'm not just trying, right? I'm not just like, let's just see what happens. That I'm going to set aside my own money. I'm going to let someone else keep it in a trust account. Could be the other firm. Could be the closing attorney. Somebody's holding on to my money. That buyer's willing to part with their money. However, it is still their money, even though it's living somewhere else for the meantime. Still their money, and it's going to be counted as a credit at closing day. It's going to be $10,000 of earnest money, just an example, could be anything. Say that $10,000 of earnest money is going to be $10,000 less that the buyer needs to bring with them on closing day. So let's say that buyer has to maybe put down $50,000 as a down payment. Well, because they have $10,000 in earnest money, they're just going to need to bring $40,000 to closing. It's credited to what the buyer needs to bring to closing. The other little item is due diligence money or due diligence fee. Fees, things that are called fees are non-refundable. Things that are called deposits are potentially refundable. So there's a big difference. Who does the buyer make the check for earnest money out to? Who's that check made to for the earnest money? The earnest money versus the due diligence. The earnest money, the one that's good faith, the one that's going to be held in a trust account, there it is. It could be the firm, but it's whomever is holding it in their trust account. It could be the attorney as well. The attorney, closing attorney, or one of the firms. It's wherever it's going to sit. The owner of the trust account in which it will sit is the one to whom they make the check for earnest money. But some of you are answering seller, and that's the other one. It's probably what you thought I was going to get around to ask. Due diligence fee is made out to directly the seller, and it's non-refundable. What do we call them both together? What's another word for both of these things together when it comes to the remedies available to the seller if the buyer chooses not to purchase? The buyer decides to not buy it. Seller gets to keep definitely the due diligence money, maybe the earnest money, and because of that, what kind of damages do we call this? These things are referred to as liquidated damages. That's what the seller's getting. And so up in the beginning of the contract, when it was first, or the offer, the seller might have been real happy about that non-refundable due diligence money, so much so that they counteroffered and said, hey, buyer, instead of you proposed due diligence of $3,000 and earnest money of $10,000, but I want you to flip it because we want the non-refundable money to us to be the $10,000, and we want the $3,000 earnest to be we want that to be earnest because we want all this money up front, non-refundable. So if you don't choose to buy it, we know we're getting that. But I would say, at least from the broker perspective, you as their broker should make sure you remind them, look, guys, they are both important. Now, whichever amounts you might want for either, let's just give some appreciation to earnest money, because while the due diligence money is what you're getting in the beginning, non-refundable, let's just put on an imaginary scenario here. We go, here's our under contract date, here's our closing date. Let's say the day or two before closing is a bad day and the buyer backs out. And they can do that. What if the buyer backs out a day before closing? And oh, by the way, the due diligence deadline date was way back here. But now they're a day before closing and they choose to back out. What's that buyer losing if they back out outside or after the due diligence? They've lost both, right? They've already lost the due diligence money in the beginning. Now they're also going to be walking away from the earnest money. Sure. So what if you stacked it? And so all you're getting is due diligence money and then just a very little bit of earnest money. That seller needs to think about it. They might have already hired movers. They might have already put a deposit down on the one they want to buy. And here we are with this mean old buyer backing out. So they might want to make sure that earnest money is enough in that event. Is that going to be enough to make them whole, to make them somewhat feel better about that buyer walking at such a late stage in the game? Maybe, maybe not. So as a broker, you just want to make sure they understand that they are both serving different purposes. Okay, so let's look at it this way. We have the due diligence money in the beginning at that point of under contract. We have the due diligence deadline after which the earnest money is also probably going to be given to the seller in the event the buyer walks. What is it called when the buyer brings the money to closing? What is that money in the form of, like, down payment, the loan amount that they're borrowing? It's all part of the sales price. And so what's another word for this sales price, a legal word that they bring to the closing table? It's a C word. You got it. That's what I'm after. Consideration. Consideration is that thing you're bringing to closing. That's the full sale price. Now, it's composed of a variety of things. Again, unless it's an all-cash deal, it's going to be composed of a little bit of down payment from the buyer directly. Going to be composed probably more of loan amount they're borrowing. All those things add up to the sale price, also called the consideration. And the reason I say that is the test wants to ask you things like, is due diligence money and earnest money consideration? And no, they are not. Consideration is what you're paying for the house, the sale price. Due diligence money is not consideration. Earnest money is not consideration. Easy points. I've seen it on practice tests, so be looking for that sort of thing. And then another thing, earnest money and due diligence money are what's the minimum? What's the minimum you have to put down for earnest money and due diligence money? The bare minimum required to have a valid contract is how much due diligence money and how much earnest money. Nothing. If the seller's willing, good luck today, but maybe in 3 or 4 years, it'll be a different market. And then maybe a seller will have to take what they can get. But as far as negotiation goes, you could have 0 due diligence money, you could have 0 earnest money, and you could have 0 days for the due diligence period. It's all negotiable. Everything's negotiable. The whole thing, the closing date, the sale price, the seller concessions, probably none, but sometimes, if the seller agrees to it, they could pay some or all of the buyer's closing costs with lender approval. So this whole thing, this whole offer acceptance, offer contract thing is all pretty much negotiable. Sometimes we have to guide our client, help them not be offended like I was today with that ridiculous offer on my land for no good reason. I know better, but I just couldn't help it. I'm just like, if you only knew. People like this place. Not me, because I'm selling it. But we have to remind them, look, guys, don't be offended at the lowball offer. If you want to be offended at someone, be offended at those 45 people that looked at your property and didn't even make you an offer. At least these folks have raised their hand and we have a shot. And then when I help you buy the next one, sometimes it's nice to throw these little subliminal suggestions there to help them realize, don't leave me hanging. I'm not here just to help you sell. I'm here to help you buy too. When we do that together, are you going to make full price? Are you going to make your best offer first? Maybe not, depending on the competition. If we're competing with a bunch, maybe you would. But if we're the only offer and it's been 100 days that they've been on the market, sure. I would imagine you might want to explore less than your full capability to make an offer. You're going to come in low too, in other words. So let's not be mad at them. Let's just see what we can do with it. We are brokers. We are counselors. We are marriage counselors. We are psychiatrists. We are babysitters. We are in search of a successful closing. That's the job description, guys. I'm not going in that crawl space to verify that thing because otherwise my buyer's not going to go through with it. And we want to make sure that repair got done. I'm a real estate agent. You know who I am? I'm not doing that. Okay, do you want to close tomorrow? I'm going under there. I'm not saying you have to. Maybe you get somebody who has to love you to do it for you. Take a picture. I'm saying the job description is not anything we're talking about in this class. In real life, the job description is get to closing. And sometimes that means paying some things that aren't fair. Buyer and seller are deciding to lock horns. They're mad at each other because they've negotiated price and they weren't happy about that, but they did it. Now then they negotiated repairs and that hurt people's feelings even more. And now they're just like, Arr. And now the seller won't fix the water heater because it's showing some signs of age. And so the only solution is the buyer might be happy and go through with the closing if they get a warranty. $1,000 home buyer's warranty. And the seller's like, well, I'm not paying for it. Who's paying for that warranty? I'm paying for that warranty all day long, upside down and backwards. To get a $20,000 commission or a $10,000 commission or a $5,000 or a two, are you with me? Maybe not two, but there's a point at which let's just fix the problem and move on and not worry about whose fault it is or whose responsibility it is. Talk to your BIC, talk to your broker in charge, see what they advise. But we put the client's needs first, and sometimes we can fix problems with things that aren't officially fair. They're legal, needs to be legal, but fair is not as much as important as closed. To get it closed, move on, make progress. But all that's subjective. You do you. Okay, auction stuff. We talked about the auctioneer needs two kinds of licenses, an auctioneer's license and a broker's license, and I owe you a break. Let me go over this one and then we'll take our break. There are two kinds of auctions, with reserve and without. Putting the house up for sale with no reserve, then that seller is just risking that it's not going to quite go back and forth to the point that they are happy, right? They're just going to gamble that the buyers will be so excited about the possibility of getting it at a deal that they're going to keep outbidding each other and get it maybe up to a price where they're happy with. Or if they're not so confident in that situation happening, they could set a nice safety net in the form of a reserve price and say, yeah, okay, long as it gets to 350, then I'll honor the bids. Whoever bids higher over 350 wins. But if they don't, if none of them make it up to 350, then I'm not going to sell it for anything less. So that would be an auction with a reserve. When we come back, we'll finish up a little bit of a review on chapter 9, and then we'll get on into 10. So I'll see you in 10. finish this chapter 9. Review. Statute of frauds. There are a handful of documents that fall under the statute of frauds, meaning they must be in writing to be enforceable. Does a contract have to be in writing to be enforceable? That's a good one. Contracts for real property. Look, it's right there. Oh, does an option to purchase have to be in writing to be enforceable? Oh, looks like that's there too. And then here's that weird one. We'll get more into it when we get to leasehold estates. But if it's a lease that's longer than 3 years, not a 3 years or less, but a lease longer than 3 years must be in writing to be enforceable according to the statute of frauds. Tell me about a listing agreement. We got into that in chapters 7 and 8. So first of all, does a listing agreement have to be in writing? Listing agreement where the seller is hiring you. Before you can market the property, yeah, you got to have that listing agreement in writing. But why do you have to have it in writing? Is it because of the statute of frauds? Is a listing agreement required to be in writing because it falls under the statute of frauds? Can you tell from my tone that that is a no? It's because the Real Estate Commission made a rule that says listing agreements must be in writing. Before you can market the property, you got to have it in writing. There is no oral listing agreement option. With regard to agency, there's only one type of agency agreement that can be not written, and that is buyer agency, and that's not even for the whole duration of a transaction. It's only good up until the point at which you write an offer, right? But the fact that agency agreements have to be in writing is not because they're they fall under the statute of frauds in basic contract law. It's because the Real Estate Commission has made it a rule that they must be. So watch out for that sort of thing. How about electronic signatures? Can you sign a document without printing it out and using a pen? Sure you can, and it's legal and valid. What is the legislation? What is the act that makes that possible? What's the thing that says electronic signatures are legally binding? Do you remember? You're close. There it is. UETA. UETA. Uniform Electronic Transactions Act. That's the thing that says e-signatures are binding, just as much as if you printed it and signed it with a pen. It still creates a legal contract. Now, when you run into the word termination, another word for that you might see instead, that they might use instead of terminate, when does a contract terminate, is discharge. When does a contract discharge? It's a legal term, not a great word, but it's what it means. Discharge, same as termination. But we talked about an offer terminating earlier. I wrote it out on the iPad, but now we're not talking about an offer. We're talking about a contract. The parties have agreed to it. We are under contract. It's an official enforceable document. It's not an offer. It's an actual full real deal contract. So thinking of that, in what way, after giving you this big fat hint, get rid of it, in what ways could a contract terminate? Ooh, that's a good one. Mutual agreement of the parties. Parties could say, you know what, let's don't do this anymore. Let's just stop. Go our separate ways. That's my favorite one, Zach. Fully performed. That means somebody's getting paid, right? We did the work. We earned it. Thank goodness they're not agreeing to terminate in which case we're not getting paid unless we were to maybe sue. But you got it. Good job. Full performance, agreement of the parties to terminate it, impossibility to perform it, or operation of law like a bankruptcy. All of those are ways that a contract could terminate. What about the death of the buyer? The death of the buyer. Does that terminate a contract? How about if the buyer is getting a loan? The buyer has to qualify for a loan to buy the property, and the one who needs to get the loan dies. So think of it that way. Remember it that way. A buyer's death kills a contract. But the death of the seller, does that kill a contract? Seller dies and the estate and the heirs have to honor it. Seller dies, the contract's still in effect. What about an offer? If the seller dies, is an offer still in effect? Throwing words back and forth. Offer versus contract. There's some big differences. So what you could do, there it is make a chart. Charts are good. Seller death. Does a seller death terminate a contract? No. Does a seller death terminate an offer? Yes. Does full performance apply to an offer? No. Contract it does, but not for an offer. What are you performing? You're just making an offer, right? So full performance is a way that a contract terminates, but it's not a way an offer to purchase terminates. What about agreement of parties? Yeah, the parties of a contract could agree to no longer do it anymore, and the parties of an offer could too. Impossibility of performance, that's a contract thing. Operation of law, that's a contract thing. Rescind or rescission, is that something you can terminate a contract with? One of the parties says, I don't want to do this anymore. Can they just do that unenforceable? Not a problem. Or do you need more information about that specific contract? Because maybe if the contract in question is in fact voidable or void, then yeah, you bet. In the case of a voidable contract, that person that's either not 18, sane, or sober, yeah, they can rescind, right? So you got to get creative and think about, and this is where this is becoming a level 2 or a level 3. This would be more of a level 3 kind of thing. You're having to take what you've learned and process a situation with your knowledge. Because typically, yeah, okay, if it's a normal contract between two parties that are both 18, sane, sober, then no, contract could not be terminated through rescinding without consequences. But it actually depends. If it's void, then yeah, the thing about consequences, both parties could enforce it upon the other. Sorry, valid. That'd be valid. If it's voidable or void, though, sure, somebody could rescind, somebody could back out with no penalty, with no consequences. So just be able to apply that sort of thing. So we'll say maybe. And we'll say yes, an offer can be rescinded up until the point at which it has been accepted and communicated. Let me say that again for those in the back. An offer can be rescinded up until the point at what? When can an offer be rescinded? Anytime. up until the point that the acceptance has been communicated. I know you can't read that, but I'm kind of using it as an illustration here. So yeah, an offer can be rescinded as long as they haven't communicated their acceptance yet, they being the other party. I think that about covers it. Make these charts. We have various things. We could talk about buyer agency agreements versus listing agreements, compare and contrast. Any sort of level 2 stuff, you can apply this compare and contrast thing. A couple of the terms we got into: assignments. What is it? It's when a buyer assigns their rights to a contract to someone else for money. They don't want to go through with the closing, and they know another buyer, maybe another investor, and they say, hey, investor buddy, if you pay me $5,000, I'll give you this contract. I'll assign it over to you, and you can be the one that benefits from buying it for a pretty good price and then flipping it, spending a little bit of money to fix it up and sell it for a big old chunk of profit. I don't want to do it. Maybe I can't do it, can't qualify for the loan, but I got them locked into a contract. And rather than just let this thing go away because I can't perform on it, let me assign it to you real quick for a couple bucks. But the thing about an assignment is it's allowed unless it's not allowed, right? That's a brilliant statement, right? Contract would have to say if it's not allowed. So our standard 2T contract says, yeah, you can assign this as long as all the parties know about it. But if the contract said no assignments allowed, then obviously you can't assign that contract. So you could write it in. And then the other thing is the one assigning it to the other buyer. Buyer 1 is the assignor. Buyer 2 is the assignee. That assignor, buyer 1, is still a little bit on the hook, responsible in case the one they assign it to, buyer number 2, cannot perform. Because this was a prime way of kind of abuse of desperate sellers by KG investors once upon a time. They never intended to go through with the purchase. They got some desperate seller to sign a contract because they just had to get money, and they promised them, yeah, we could close in 2 weeks. And that seller's hoping to save from foreclosure or bills or whatever. They enter into the contract, and 2 weeks comes up, and that buyer is just gone. And the one that they assigned it to couldn't even qualify. And that seller's taken advantage of. So the other thing about an assignment is that first buyer is still secondarily liable for the second one performing. If it all went south, the second one would be, they'd go after the second, but the first does still have some liability for that performance taking place. We've seen this phrase a couple times. Time is of the essence means hard date. As of this time, on this date, not a second past it. That's what time is of the essence means. The parole evidence rule, the verbal stuff that we talk about up front, doesn't matter if it doesn't make it into the final signed contract. In other words, here's how it comes up in real life. The seller writes it up in the multiple listing service, or the agent does for them. The refrigerator is going to stay with the property. But maybe because of hurt feelings and negotiations that went south and the price was low and the seller's mad, and the repairs, they ask for too much and the seller's mad, and the seller says, well, I'll show them, instead of leaving the refrigerator like I promised, I'm taking it with me. That'll help me feel better from having to spend that extra $2,000 I wasn't planning on. And the buyer comes for the walkthrough and they see no refrigerator, and they say to their agent, wait, what about the refrigerator? What's the first thing you're going to do as the buyer agent when your buyer says the refrigerator's gone? They said they would leave it. What's the first thing you're going to do? Look at you pros out there. You guys are great. You're going to look at that contract, you bet. Look at the receipt. Check your receipts, right? The contract's a big fat receipt. What's the contract say? Oh, and here's the moment where you're the buyer agent and you're reading the contract, and you remember you have the listing agreement. The MLS agreement in the folder from back when you first found that property for them, the MLS data sheet, and it said refrigerator to remain with the house. And you forgot to make sure it got put into the contract. Who's buying a refrigerator for your buyer? An attorney would probably say you can either buy them a refrigerator or you can have them turn you into the real estate commission and then buy them a refrigerator. That's a big one. You won't do that twice. You'll make that mistake one time. So that goes back to this idea of the parole evidence rule. Make sure whatever's important to them makes it into the contract, especially with regard to fixtures versus personal property. If somebody decides to get fancy and not honor their contract terms, that's called breach. What are the consequences? Well, in courts of law, we've got a couple of kinds of damages. Compensatory is making someone whole again. Consequential has to do with lost profits. Rescission means let's just go back to the way we started. Here's your money back. Here's your property back. We're just gonna pretend like this never happened. But what of all of this applies when a buyer breaches? What remedy is available to the seller in the case of a buyer breaching or a buyer choosing not to buy? Whatever has been listed as earnest money or due diligence. That is it. That's it. That's all the seller gets. According to the standard contract 2T, earnest money and due diligence money are liquidated damages the seller gets if the buyer doesn't go through with it. And then flip it. What if the seller backs out? Seller says, you know what? Just kidding. I don't want to do this. I realize this is my home place. I regret it. I'm nostalgic. I don't want to go through with the sale. The buyer can sue them for specific performance. They like to flip these on the test. Don't let them get you. So if the buyer breaches, the seller, listen to me, would not sue the buyer for specific performance. That's not a remedy available to the seller. That's only a remedy available to the buyer. Because what is specific performance? Performing as per that contract for that very unique property. Because all real estate is unique. It's location, 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 you know? It's a common type of value. It's a characteristic of value is uniqueness. So that buyer could basically sue the seller because they aren't performing, aren't selling them that property, that exact property. Can't just swap it out for another one because everything's different. And then in addition to suing them for specific performance, they could also, by the way, sue them to recover all of the expenses they've incurred to try to buy it before it all went sideways. All the inspections, which could be a couple $1,000, appraisal, survey, all that stuff. All right. And that's about it for 9. It was definitely a valuable exercise to repeat all that. I need to make sure that that is firmly in your brains because highly testable. And it crosses up with chapter 10, which is what we're getting into now. So join me, won't you? Chapter 10, sales contracts and practices. We'll look at the actual paperwork and our procedures. There we go. All right, so let's take a look. George decides to sell his personal residence and offers to sell it to Larry by means of a letter. Sends Larry a letter, says, I'll sell it to you for $350,000. The next day, George gets a note from a neighbor who writes, I accept your offer to sell your home for $350,000. The neighbor is not Larry. It's a neighbor, not Larry. Is George obligated to sell it to the neighbor? Yes or no? Not sure how this neighbor found out about it, but it's none of their business, right? This is between George and Larry. Larry doesn't want to buy it, fine. But George didn't make the offer to the neighbor, did he? So first step is, it's not enough to just see yes or no. It can help you weed it out, because you could read them and think, well, I'm not sure why it's a no, but it's one of the two no's. So let's get rid of the yeses and focus on the no's. So is it a no because George did not make the offer to the neighbor, or because the neighbor didn't wait for Larry to accept it? Which no is the best one? And don't forget, guys, when you're going through the practice exams and the real exam, they can only fit so much detail into these questions. Sometimes they put quite a lot in there, more than you need. But the overall rule of thumb when reading these test questions is, which one is the best answer, right? If you find yourself reading more into it, like, yeah, but, anytime your brain goes to, yeah, but, you're adding too much in. Stop, take it for what it's worth, face value, read it, and work with those 4 or 5 lines in the question. And answer it with the best answer for the given facts. And you're all killing it because you're right. Number 3, George didn't make an offer to the neighbor, so it's not for the neighbor to say yes. George might agree, but the neighbor had no role in this at all. We've got some recall, meaning level 1 stuff in this chapter. What is an installment land contract? We know what an option to purchase is. We'll talk about preemptive rights. Some application is level 2. We'll look at the actual contract. I'll give it to you. I think I've already put it in the Google Drive, but I'll make sure. Some analysis, that's level 3. We'll get deep dive into the contract, standard 1, and some procedure stuff. So tell me this. What is a deed? Let's recap. What is it, this deed thing we talk about? Not the answer to this question yet. Just tell me again what a deed is. Could be a one-word answer. Could be a phrase. You can liken it to a car. There's a good word. Ownership. Sure. Proof of ownership. Yeah. Title. Yeah. Title to the property. By the way, does a deed need to be recorded? Yes, you bet. In order for it to be considered having closed, yeah, in North Carolina, and also to be enforceable against third-party claims, must be recorded to do that. What's the word for the legislation? Sort of like statute of frauds, but that's about something being in writing. What's the other one that says something needs to be recorded to protect it against third-party claims? Some kind of an act. There we go. The Connor Act. Get that one down. Statute of frauds must be in writing to be enforceable. And the Connor Act says must be recorded to protect against third-party claims. Cement that in your brain, just like the 4 little old ladies going 35 and a 60. That's one of those. Just put it in there in the never forget category. Okay. The contract, of course, is the thing that puts promises in place for both parties. So compare the deed and the contract. Which document is more important? A deed or a contract? This is a level 3 question. Think about it a minute. And it's not both. Marcus, I like your logic. However, let's think about that a little more. Is it indeed true that with no deed we have no contract, or is it the opposite of that? Because what comes first? Right? The deed in a transaction is going to be made based on what they find in the contract, right? The attorney is going to write up the deed after they look at the contract to see who it's going to be between and what they're trying to accomplish. Because don't forget, something else that would go in that deed would be Maybe it's a fee simple defeasible kind of a thing. Oh, gosh, we never thought we'd have to see that again until the test. But that could be a thing that needs to be incorporated into this deed. And so therefore, how is they being the attorney? The closing attorney is the one who writes the deed. Therefore, how is that attorney going to find out these things? They're going to read the contract. So it's actually the contract is the most important, and that's all useful. Hope you don't feel like I'm picking on you, because it's useful to think about it, go through it, and get it wrong, because you'll never forget it. You'll be like, oh yeah, okay, now that logic makes sense. So the contract is more important, and I don't even like this question, but they throw it at us, so here it is. More important than the deed, because it determines the terms of the deed. It's what dictates what the deed's going to say, right? There is the existing deed that the seller has proving that they're the current owner, but that's not the deed that's going to get signed over, right? That's the deed they got when they bought it, but a new deed will be written by the closing attorney based on what he finds and sees in that contract. So there's more than one deed, right? There's the one the seller has, and then there's the one that the seller is going to sign, a brand newly written one that applies to the current transaction. Here's a big one they like to test you on. We have a broker's license. You're going to have a broker's license to do real estate. And as much as we like sometimes for the convenience factor, that doesn't give us the license to write legal contracts, like from scratch. What can we do when it comes to making an offer? Can we pull out the old typewriter and type it up fresh on blank paper for our client? And if you just thought, what's a typewriter? Raise your hand. Just kidding. You see, once upon a time, we can't draft legal language. Thank you, Catherine. All we can do is fill in the blanks. We'll fill the heck out of some blanks, right? We can fill in blanks. We can't write them from scratch, whether it's a contract or an addendum or an amendment. And it would be so quick and easy if we could. Sometimes client says, I want to incorporate this thing in this agreement. Can't you just write one up real quick? And you say, no, but you can. Or better yet, let's get an attorney to do it. Because that's the other one. Who can draft language when it comes to a contract? Easy answer is not you, not the broker. The parties to the contract can do it because they're parties too, or an attorney. And even though it might be my brother-in-law who's super frugal, aka cheap, he might want to write it himself, but I'm going to tell him, I know you want to save money and you want to write 2 sentences to accomplish this goal, but those 2 sentences might not be enough to protect you. That's sort of what the attorney is good for. If they know we really, and it's a moment where we all roll our eyes. Yeah, the attorney's going to make it into 3 pages and all it needs to be is 1. Maybe not. Maybe you don't have enough protection unless they write it into 3 pages. So just as a broker, get it off your shoulders. Be on the record as saying, yes, you could draft the language yourself, but let's get an attorney to do it. And oh, by the way, a little hint from the street in the wild, if you use the closing attorney for this little drafting of legal language, addendum, or amendment, they might not charge you. It might be an existing relationship and they might just be nice to them. Be nice to your vendors. Send them thank you notes and gifts and things, and then call that paralegal and say, hey, my buyer wants to use an escalation clause. We'll talk about that another time. Do you guys have one that we could have? I can't write it. It's not a standard form we have available to us. Would you happen to have one, or could you write one for us? Or an appraisal addendum? An appraisal addendum is something that came up in this business last couple of years, and that basically is a way for the seller to say, hey, buyer, just letting you know up front when you make your offer that I'm not coming down. I don't care if it doesn't appraise for this price you agreed to pay, this ridiculously high price you agreed to pay. It's going to fall on you if it doesn't appraise. I'm asking $350, but a bunch of people made a bunch of over asking price offers. And if you offer 400 and it only appraises for 340, then you're going to have to come up with that extra $60,000 between the 340 appraisal number and the 400 that you just promised to pay me. Don't ask me to come down from my price. That's what an appraisal addendum is. By the way, that's the options. There are 3 ways to handle this thing. We'll get into a little more with finance, but we would have a sale price agreed upon, let's say $400,000. The parties agree we are under contract for a price of $400,000. But since the buyer is going to get a loan, the lender wants to know, what does a intelligent third party called the appraiser, what do they think about the value? We know the buyer was willing to pay this because they're fighting against 14 other buyers, but is it worth that? Are we going to make a loan based on this price? We're not going to trust the buyer or the brokers or the seller. We want to know from a disinterested third party, what is it appraised for? And that appraisal, as we get into chapter 17 later, that appraiser might say, well, I've looked at all the comparable sales in the neighborhood in the last couple of months. The best I can come up with is this property is actually worth $340,000. That's a bad day for all the brokers and the people involved. Because guess what? That buyer's not going to be able to borrow 90% of $400,000. They're only going to be able to borrow 90% of $340,000. I made up the 90. It could be whatever loan amount they're getting, right? This is what the loan's going to be based on. So here are the options when an appraisal comes in low. Either the seller could come on down to Biscuitville, SNL reference, anybody? Could come on down to the appraised value. Either the seller could do that, or the buyer could come all the way up by adding the extra money difference to their down payment, in this case $60,000. Or the seller could come down and the buyer could come up and meet somewhere in the middle. Buyer could only maybe bring $30,000 more and the seller could agree to come down by 30. You see, so it'd be either buyer fixing it, seller fixing it, or both doing something. Or a fourth possibility, it blows up and we don't have a sale. Because the seller might say, by using this custom-made drafted legal document called an appraisal addendum, that this thing about me coming down to that is not happening. I'm going to let you know that from the beginning. Appraisal addendum says, hey, buyer, you're going to have to fix it if it doesn't appraise. Not my problem. Welcome to a seller's market. So I said all that to say this. Don't write that thing yourself. Get the attorney to do it. And they have standard ones. Last couple ones I try not to use them because here's the other thing. Last time I was a listing agent and a buyer brought me an offer for my seller with an appraisal addendum, they said, we're not going to ask you to come down, seller. You should pick us over those other 9 offers because we won't ask you. Guess what? It appraised $16,000 low. And they said, would you at least split the difference? And I'm like, you shouldn't be asking me this. You promised you wouldn't. So what good is the appraisal addendum if there's no like enforcement or penalty? Like if you ask, we're going to charge you. That's not a thing either. So it's kind of pointless. The buyer still has the right to back out during due diligence and get their money back, their earnest money, right? So it's kind of one of those things. Sometimes clients ask you for things because they saw it on HGTV or heard about it from their cousin that sold a house in Oregon, and we don't really do it that way here. But if we draft something ourselves, that's unauthorized practice of law, being an attorney without a legal license. Okay, what you also need to do because of your old car, what's the last letter of car stand for in your fiduciary duties of old car? Tell me more, Joseph. I've been talking from the cuff so much I don't remember what I was talking about. There you go. Reasonable skill and care. Yep. That means we need to know what we're doing. That's when your broker in charge steps in and says, here's how we do this thing in real life. Yeah, you learned the laws and rules with that guy Neil, but now you need to know how to do real estate. and then that's when you're going to learn real estate. Oh, it happens more than you think, a low appraisal. It really depends on the area and how much activity has been there. If it's a pretty unique property, it might be pretty challenging because that appraiser has to find, and somehow they're going to have to cut and paste more. If it's not a neighborhood full of properties just like that one, then they're going to have to figure out what houses like that have sold for with different acreage sizes, and then what is acreage worth, and put it together. And sometimes the appraiser sucks. They're just bad at their job. Not often, but sometimes they don't understand the area. Maybe they came from across 50 miles away and they took the job even though that's not really their market. So they still come in low. And when this market first turned into this thing it is now, there weren't the comps yet. And we had a lot of appraisal problems then because while we had lots of buyers willing to pay higher prices, we didn't have the sales yet to justify it, to base it on, and to get the appraisals. So it happens less now, I think, but it still happens. So we need to know, sort of. Comment was the appraisers hired by the bank. Since 2008, yes. Prior to that, the bank picked the appraiser. And so if the appraisal came in low, the lender, meaning the bank, the lender, might say to the appraiser, you know what, we really need this one to go through. Are you sure you can only appraise it for $340? Because we really need it to get to that $400. I would hate to stop using you as one of our chosen appraisers. Why don't you make this happen? Well, guess what? That led to loan fraud. A lot of loan fraud from that sort of fictional stuff. So now, since 2008, it's a different system. It's a third party that schedules the appraisal. The lender reaches out to that third-party company, says, we need an appraisal on such and such, and they do it. The lender can't talk to the appraiser anymore to keep that distance in place. Do you see appraisals come in for exactly what the house is under? A lot. As always, yeah, because this is sort of the thing I've always rolled my eyes at. The appraiser knows what the sale price is before they do the work. Now, they're still held to a standard. They're still governed by the appraisal board of North Carolina, but they do, it's sort of like, the math is easier when you flip to the back and see what the answer is first. So they do see what it kind of needs to be, but their job is not to come up with a value from scratch. Their job is to justify that sale price with real evidence of what buyers have been willing to pay for similar properties. And so the big question mark is, from one appraiser to another, or one broker to another, whoever's doing the valuation stuff, is what is that appraiser's opinion of how much a square foot is worth? Two different appraisers might have two different answers for this given neighborhood. One of them might think, I need to make an adjustment for the difference in square footage of $83 a square foot. And another one might say, oh no, I think it's more like 97. So it's subjective in that way, based on their experience, based on their observation and research, but there's no magical book. There's no, here is what a fireplace is worth. It depends. A fireplace is a lot different in Lake Norman on the ocean front. I think in Cabarrus County, I just saw there's a maybe $6.1 million house for sale in my county. I bet that fireplace is worth more than the car in the in the driveway of some neighborhoods that are on the other side of the county, right, for $300,000. So all that depends. Yeah, you got it. It is strange when it's to the dollar, but there is sort of like they just have to have proof that that it's worth what it's worth. So we need to know what to use and when. That includes addenda and amendments, what needs to be attached. And when you first start in the business, your broker in charge will help you with that, and you'll make a list. You'll be like, oh, for future information, If my buyer is getting an FHA loan, there's an FHA addendum I need to include. If it's a house built before 78, we need to make sure we add that lead-based paint disclosure and that sort of thing. Oh, you want to put a deadline in? Then we're going to need the additional provisions addendum. Oh, we're under contract and we need to adjust the amount the seller's going to pay toward the buyer's closing costs in lieu of repairs. Seller didn't want to fix anything, but they will give $2,000 to the buyer to go toward their closing costs. There's a special amendment for that. So you need to know what needs to be used and when. And we get them through the NCAR, the National Association of Realtors. Let me show you that. We'll get more into that in post-licensing 302. There we go. And so you'll become a member of the Realtor Association, and that's 3 different memberships. That's the NAR, the National Association of Realtors. That's the NCAR, which is the North Carolina Association of Realtors, and it's your local board as well. So that's like it's split up. Your dues are split up into those 3. And if you log into your NCAR membership like I'm doing here, you have access to all the forms. They're also available probably through your office, but you can always get them here. And you've got them, the 100 series are the seller related things. The 200s are the buyers. You're not going to be tested on any of this. I'm just showing you there's a ton of forms that we have to pick from. There are plenty of things that we don't have. For instance, what's not in any of these lists of available forms that are pre-done? A couple things that are not. One of them is a contingent sale addendum. Contingent sale addendum, meaning if the buyer needs to close on their existing house in order to buy the one that you're helping them buy, otherwise they can't afford it. They got to sell what they got in order to buy what they want. The contingent sale addendum, you put that in place so that they have a protection. If that doesn't sell, they don't have to buy this. But it doesn't exist anymore. A couple years ago, they did away with it because it was confusing and people didn't use it. What else could you do if your buyer wanted to be sure they could still back out if they weren't able to sell their house? What's a way you could do that without some special contingent sale addendum form? No, Catherine, you don't need to worry about. You just need to know what certain addenda do, but you're not going to be tested. That'd be more of a post-licensing. The question was, for the test, do you need to know which addenda for what certain situations? Only in that a list of addenda that we'll go over here shortly, which ones accomplish which thing, but it's not super detailed. What could you do if your buyer needed to sell a house in order to buy the next one without a special form for that? What they're trying to accomplish is, I just want to be able to back out if I can't get my house sold. All you need to do is have a long enough due diligence period to try to get it sold, right? So maybe instead of a 2 or 3 week due diligence, you say, well, look, seller, I need to sell my house in order to buy yours. So I'm going to need like a 6 week due diligence period. And good luck. Hopefully the seller will agree. But that's what people started doing. Instead of using an addendum, they just said, let's prolong our due diligence period and try to get it at least solidly under contract. Very confident it's going to close so that we know we can go forward with the purchase of the next thing. So that's an example. That's sort of what I'm talking about there. Oh, another thing that's not in this list available to us is any sort of seller financing document. So in a little bit, we'll see that something called an installment land contract, and that basically is seller financing, meaning the seller is going to be the bank. The seller is going to finance it. So instead of giving that seller the entire sale price, you're just saying, I'll make payments to you instead of Wells Fargo. Well, there is no standard form for that because it's very complicated. It would be both a contract combined with a finance document, and that is way out of our scope, right? we would need to have an attorney draft that sort of a thing custom made for the situation. There's no magical, just fill in the blank form for that. And also, yeah, good point, Joseph. Perfect example. Lease with option to buy. Yes, we have a lease. And yes, we have a contract or offer to purchase. You can't, as brokers, we can't just put them together and have them sign both and attach them to each other. It would need to be a special form for a lease with an option to buy kind of a situation. Another thing the attorney is going to have to create from scratch. So besides that, we get our contracts and forms, as you saw, millions and millions of them, well, dozens and dozens, from this North Carolina Association of Realtor, in conjunction with the bar. And as long, here's the other testable thing they like to throw at you. Only people who are realtors or attorneys can use those specific forms that I just showed you, like the Series 100, 200, all those. If we had clicked on each of those categories, the offer would have just been scrolling and scrolling and scrolling. All kinds of amendments and addenda, commercial and residential and property management and seller and buyer and agency. But those are fill in the blank. Oh, let me show you one, and then we'll take a break. So if we go to any of them, here's a listing agreement. And you scroll to the bottom, boom, that's who can use it. A realtor. There's the, North Carolina Association of Realtors. So an unrepresented seller, a FSBO, right? If you want to make friends with them and try to win them over and maybe hope that they give up trying to sell it themselves and let you try, and they hire you, you might want to give them a sample contract like this. This one's for vacant land. But if you were to give them this and then say they don't choose to list with you, they just find a buyer themselves and let that buyer use this form, that's not allowed. Only a transaction with a realtor involved can use this form. An unrepresented seller selling to an unrepresented buyer with no agent in sight better not use this form. Can you give this to them? Yes, as long as you have the word sample across it. And all of these forms have that possibility. And there's a whole category of all the sample forms. And that's the difference. So the sample version conveniently already has that word superimposed across it. So if you're giving stuff out to people just to win over, make friends, influence people kind of thing, make sure it's unusable. They can read it, maybe try to make one based on this as an example, but they can't use this one itself. So that's what you need to do when you're giving out free stuff. All right. Let me give you a free break right now. I'll see you back in 10 minutes. copy. Okay, welcome back. Let's get back at it. Cash and prizes. All right. So we need to know what to use, what forms to use. We also, making sure you can hear me. Thumbs up. Still good? Thank you. Here's how the Real Estate Commission says you need to fill out your forms. Guess what? Keep it legible, right? Make sure there's no questions. Make sure you type or print legibly. Fill in all the blanks. Sometimes I get offers, and maybe it's because of the electronic signing software. And if there's nothing to put in that particular blank, the blank is blank. Blankety blank. What's wrong with that? Well, who could put something else in there? And here you have a signed offer, and it has a blank here. You want to put something in there, even if you're not using it, right? NA, none, 0, something like that, but never just blank. That's what the Real Estate Commission's talking about there. Be precise, be specific and be precise. Make sure that people understand what this thing is accomplishing, that the goals are being met. Don't use fancy abbreviations that nobody knows the meanings of, acronyms, jargon. Be clear, basic language, third grade level language. And don't be ambiguous. Don't write things that are hard to figure out. Because if it ends up going to court, then the judge will find the person who wrote the ambiguous language. They'll rule against them. They'll rule in favor of the one that was the victim of the ambiguous language, right? Difficult to understand, unclear, ambiguity, ruled against. And then, of course, this thing, statute of frauds, must be in writing to be enforceable. She's going to kick you out if you can't produce the agreement in writing. The in writing part just means this. You bet you can do it on your phone. I've written offers on this phone before. It's no fun. It's tiny and it's hard to get to everything. It's not my preference, but it's legally a possible. And that's because of the UETA. Uniform Electronic Transactions Act says, yes, you can sign electronically and it would still be legal. So we can save all the trees. You could get away with an entire transaction that doesn't have any paper. Could have 0 paper involved, maybe until you get to the closing. But even then, there's been closings with everything signed digitally as well. They tend to not be. They usually print them out and have them sign. And there are a couple of documents that have to have what's called a wet signature. If you see that term wet signature, that means pen on paper, not digital. Pen on paper, like the ink could be smeared, wet signature. What's the most important document in real estate? The deed or the contract? Look at you guys with your short-term 2-hour memory. Your memory goes way back than that. You guys are doing great. Good job. The contract informs the deed, therefore it's the most important one. What about if a term needed to be added to an offer to purchase? OTP, offer to purchase, offer, not contract. Should the broker just write it in? True or false? Yeah, we can't be creating language, right? We can't draft language. That's another word. If you see the word draft, it probably is referring to drafting legal language, and that is not allowed. But you're right. Some of you said use an addendum for that. Some other sort of fill in the blank pre-printed provided for form. Yes, that'd be a way to do it. Or do I see that? What's some other ways to, what's a way that drafted language could become part of the offer to purchase? Who can draft the language? As long as it's not you. Best choice, Marcus, you're right, attorney. But also, legally, And officially, yeah, the parties themselves. It's just good practice as the broker to say, look, I know you can do it yourself, guys, but let's go ahead and have an attorney look it over. Make sure that all of your bases are covered. You're completely protected. Starts with this thing, this offer to purchase, and notice it's both. It starts its life being an offer to purchase, and then it could possibly, hopefully, become a contract. So it's both. It's an offer to purchase and contract. Now, the Real Estate Commission has a rule, and they say, yes, brokers use pre-printed forms, but here it is. In order for a broker to use a pre-printed form, that form has to have 19 specific provisions in it. Here's the good news. You don't need to know them. You do not need to know them for your pre-licensing exam. Just know that they're there, that they exist, that there are 19 provisions. If you want to know them, you can just look up Rule AO112. It's in your material. It's in the rules section, the 58A kind of rules section. And oh, by the way, anytime, again, you're looking up general statutes, because who doesn't want to do that in your spare time? Let's see, 0.012. Let's see if that's enough of a Google search. Oh, look, there it is. That's how easy it is to look this stuff up. And let's see if that's actually the right thing. That's not quite it. There we go. There it is. So again, you won't be tested on these items, but I just want to show you, well, actually now it's considered 20, but a broker acting as an agent in a transaction shall not use a pre-printed offer or sales contract form unless the form has the following, basically. And let's just look at a couple of them, because I'm pretty sure if we formed our own committee and decided to put this together ourselves, we would come up with most of these. It's common sense, right? Maybe we should have the names of the buyer and seller. Oh, great idea. The commission thinks so too. Maybe we should make sure it's the right property, the legal description. Maybe it should also, these rules also say if there's any personal property included, make sure that's in there too. So again, in order for us as brokers to use a pre-printed form for a transaction, it has to have these things in it. Whoever you hire to make you could have a custom made one. You could hire an attorney to make your own pretty one that said Samantha's version of the offer to purchase and contract, right? SamanthaSells.com, if that's her thing, right? And have your very own, but as long as it has these provisions, then she can use it. She can't use it if it doesn't have every single one of these provisions built into the pre-printed form. You with me? Obviously, purchase price, manner of payment. If there's going to be some financing, let's see, earnest money, that makes sense. Acknowledgement of a loan that the buyer might need to get. Closing date, signatures of the parties, and some other stuff. So you can look it up and kind of take a look, get familiar with it. But again, they won't say what's item 17 of the requirements for a pre-printed form. They're not going to put you through that. And at the end of the day, the buyer and seller could make their own. They could make their own version. Now, you can't help them with it, right? If they do make their own pre-printed version that they want you to help with, again, in order for you as a broker to help and say, fill in this blank here, it's got to have those 19 or actually 20 provisions in it. Again, don't need to know what they are. Just know that that's a thing. There are two provisions that are not allowed to be in the contract. What cannot be in the contract? Let's go back to the actual rule again. And they're at the very bottom. A broker acting as an agent in a transaction shall not use a pre-printed offer or sales contract that has the following. These things cannot be, spoiler alert, it's stuff that relates to you. Can't be in the contract, you the broker. Things about the brokers can't be in the contract. What things? The commission or compensation. We don't handle that in the contract itself. That's a you thing. You broker, you. It's not a thing between seller and buyer. How do we acknowledge how much you're getting in all of this? That's going to be handled in the agency agreement that is a separate document from the contract. The contract itself should be purely the terms between the buyer and the seller. That's it. Does your name show up in the contract? Yes. On the second to last page where it says this is the agent for the buyer and this is the agent for the seller. But nothing about your compensation is in there. And then the other thing that cannot be in a contract is another related to you, and that is a disclaimer of liability of the brokers. In other words, you can't put in there as a broker, hey, I might be really bad at this, so you're not going to sue me if I screw up this contract. You can't cover yourself with a liability protection clause in the contract. Agent might be terrible, therefore don't sue me, bro. It cannot be in there. So no disclaimer of liability and no mention of commission. One time, in the not so distant past, I had a contract, an offer come in, and it happened to be the one that my client, my seller was most, I think I might have told you, was most interested in. And this particular seller was choosing to pay a 2.5% commission to the buyer agent. This buyer agent did not like that. She wanted 3%. And so she just went over to this offer to purchase and contract, whizzed on down to the addenda section. Let's see where it's out. There it is. And right here under other addenda, they wrote in addendum A. And addendum A said, seller to pay buyer agent 3% commission. She just inserted herself right into that contract, right into that offer. It wasn't a contract yet. And that's exactly what we're talking about. That's not allowed. You can't put your commission in there. You don't handle it with this thing. This is between the buyer and the seller. How do we handle commission? If that was that important to her, she could have called me ahead of time before writing an offer and said, look, couple things. She could have either said, are you sure? Could you ask your seller if they would pay a 3% instead of 2.5%? Low likelihood, right? Probably wouldn't work and not probably the greatest solution. But here's the other possibility. She could have also gotten the extra that she wanted from her buyer, because that's how that works. Let me show you. I have a lot of forms. Oh, there it is. Now it doesn't want me to click on it. Oh, there we go. It's taking its time. But at the bottom of, I think, page 1 of this buyer agency agreement, it says, okay, buyer, I'm going to try to get paid from the seller. And usually that's how we do get paid. But if the seller won't pay me what I charge, something that's acceptable to me, then you will. You, my buyer client, will make up the difference between what I want to get paid and what the seller is willing to pay me. Here we go. All right, here's our buyer agency agreement. And we scroll there, right there. It says, firm shall seek the fee of this amount of money, whatever you'd written up here, that's your buyer agency fee that you charge for helping a buyer, from a cooperating listing firm through their offer of compensation in the MLS or otherwise. It might be a for sale by owner. And you've gone ahead of time to that for sale by owner, and you said, look, I've got a buyer baby for your house. Would you pay me a buyer agency commission? So if that doesn't get you as much as you want or as much as you charge, if buyer purchases property where the compensation offered is less than the fee that the broker charges, or no compensation offered, then the buyer and the firm agree that the buyer will pay the difference. Do you have the guts or the willingness or the relationship to ask that buyer to make up that extra 0.5% or 1% or whatever it might be? Well, it's just a business thing, right? Just talk about it. Here's how this works, guys. But I think what agents do wrong, I hear it all the time, and it's also part of the reason of a major class action lawsuit right now, is that brokers have incorrectly gotten too free and frivolous with how they talk to people about buyer agency. Brokers are incorrectly saying, sorry, I'm crying over it. It's devastating. Just kidding. Context. Brokers are saying, look, guys, if you hire me and let me help you as a buyer agent, it's free to you. You don't have to pay me anything. But that's not it. That's not the right way to explain it. You say, I'm probably going to get paid by the seller, but I might have to get paid from you, depending on the situation. And we haven't done a good job of getting in front of that. And so when you say it that way, it's going to be free to you. And then that situation arises where it's not free to them. Now who looks like the bottom of the barrel fraud guy, right? Looks like the person that's just looking for a way to stick them for money that you told them you weren't going to charge them. That's true. Question in the chat. So the real estate commission requires what specifically were you asking about, Catherine? But we can find the contracts from the Realtor Association. So yeah, most of the contracts are provided to us by our membership. Oh, right. You got it. Since the Realtor Association, North Carolina Association of Realtors, has made the contract for us to use, that standard 1-2T, they, of course, read the rule provided by the Real Estate Commission that said in order for agents to use this form, it has to have these provisions. And so, yeah, they got those provisions that are required and used them in making the 2T. But again, even if it was any random seller or buyer, anybody who wanted you to help them as a broker and fill in these blanks, that one that they have made custom would also have to have those items too. Okay. Gosh, I think I'm allergic to myself. So 2 things that cannot be in that offer to purchase and contract is broker compensation and broker's limitation of responsibilities. And we'll say this a million times, you'll get sick of it. We can't practice law without a license. Brokers can't practice law without a license. That means answering legal questions. It means writing language, drafting language, writing amendments and addenda from scratch. What if they ask you what fee simple defeasible means, and what is your advice to them as to if they should use it or not. I'm going to list my house with you, but tell me, should I sell it fee simple absolute or fee simple defeasible? You can tell them what it is. Thank you, Catherine. But you would not give advice on what they should do. You'd say, interesting question. I haven't heard those words since Neil taught me pre-licensing. Let's talk to an attorney because I'm not it. Not it. They might also, and I had this happen with a little person that played keys in a little band I played in, and she lived with her mom, her elderly mom. The mom's name was the only one on the deed, but the daughter, the adult daughter, my friend, was on the note, was on the mortgage. She had refinanced to help out her mom. So she was on the mortgage, but not on the deed. And she's like, Mom's older, and I think I probably should just protect the situation and myself. I should probably be on the deed too. How do I do that? And I told her, here's what tenants in common is. Here's what joint tenancy is. But here's an attorney you should call, and they will advise you as to what the best solution for you is. I did not give her advice. I just said, here are the options. Go do it. And when you know it, 6 months later, her mom was diagnosed with cancer, and 2 months later, she was dead. And I kind of had wondered, did she ever do that? And then I found out about 2 months after the mom died that she actually hired me to help her sell the mom's house because she ended up dating a guy and they got serious and they bought their own place, or she moved in with him. Turns out she did, thank goodness. Really soon after she asked me about that whole thing, she went ahead and got it done. So it just made that whole horrible situation at least the tiniest bit easier because they had that worked out. She was on the deed. Okay, if the buyer is using the standard offer to purchase and contract form 2T, and the buyer decides to back out of the contract after the due diligence deadline date, what happens to the money? The money being the due diligence money and the earnest money. The buyer get the due diligence fee back if they back out after the due diligence deadline? Do they get the earnest money back? Do they get nothing back? Or do they get both back? You're good. Number 3, they get nothing back. They're not entitled to due diligence money. They lost that right out of the gate as soon as they went into contract. And they're now losing earnest money too. Well done. So our standard offer to purchase is the Form 2T. You don't need to know what the form numbers are. I'm just helping you understand that I'm talking about that thing that they provide to us, they being the NCAR. And again, same stuff, no ambiguity, no abbreviations, no lack of clarity. Put things in spaces. Don't leave blanks blank. Have none or NA or 0 if it's not used. Fill in all the blanks, write legibly. When it comes to the property description, it needs to have a legal description. It needs to have every description. In fact, that offer to purchase looks like this. And it's got a place for everything. When we take 302, we'll go through it very detailed. There we go. And here it is. So first page, you make your way on down to the description here. And it's right there. What's the property? Street address, like your typical mailing address kind of thing. Is the street address a legal description? No, but it needs to be used. And so there's a place for that. And it's probably the best way to reference it. But here's the part that is legal description. And however much of it you know, but by looking up the tax record and maybe the deed, both of which are publicly available, is what you put in here. If they give a lot and a block number, which would be referencing a previously recorded deed, put it in there. If they give a tax parcel ID number on the tax record, put that in there too. It's probably 9 or 10 digits. If they reference a deed book and a page number, that's probably that's a recorded deed. Sorry, the lot and block is a previously recorded plat map. That's a map thing. Lot and a block would be a map thing. Book and page would be a previously recorded deed. And then, of course, complex or subdivision, there's a place for that. So there's plenty of places, and you just give as much as you know. You want to make sure that it's very clear what property is being transferred. According to those 19 provisions, that contract also needs to have the price being paid, obviously, the terms the buyer will offer, because it's not just about the price, guys. Tell me, if we have two offers on the table, two competing offers, one of them, let me do it this way. One offer is for $420,000. Let's say the asking price is $415,000. The other offer is for $415,000. Which one's better? Does this feel like a loaded question? What you should be thinking is, tell me more, right? Because it depends. What you should be thinking is this guy. Oh, the 420 offer is a VA loan, which means zero down payment. It's they're also asking for the refrigerator, the washer, and the dryer. They also want the seller to pay $7,000 of the buyer's closing costs. And they're putting down $5,000 of due diligence money and $1,000 earnest money. The 415 offer is all cash. They're not asking for anything else. No washer, dryer, refrigerator. They're not asking for any closing costs paid by. They are giving, well, heck, even just that. If the next two items are the same, now which one would you as a seller be tempted to take? Right? It's not just price. Terms are huge. And I haven't even mentioned time. What about this? Offer number 2 over here can close in 3 weeks. Guess what? A VA loan? No offense. I would love to help a veteran. But at the end of the day, your seller client needs to do what's best for their family. And a VA loan, yes, they could possibly get closed in 30 days, but I would probably rely on more of a 45 to 60 day term. Because guess it's the government and they got to go through some channels and it might take longer. And also sometimes the seller has to pay a couple of things for the buyer because yes, you're selling to and there's zero down payment. So they're borrowing 100% of the loan amount, like 100% of the sale price. So more hoops to jump through, right? So yeah, I'd love to help out this veteran, but if it means a quicker, faster closing and that fits my family because I'm getting transferred with my new job, all of those things. It's so much more important to look at terms than price sometimes. And if you really look at this is not a $420,000 offer. This is $420,000 minus 7 because the seller's being asked to pay $7,000. This is really $413,000. Oh, wait. Plus, now they're going to have to buy a refrigerator and a washer and a dryer because they're giving theirs up if they choose to accept this, right? So what this really is what? 413 minus another 2,500. So 411.5. Maybe I'm off by 1,000. Yeah, that's not so pretty. And all you see if you just look at the front page of the offer is the price. You got to start digging and flipping back into the thing to find the place that it says that they are asking for closing costs to be paid by the seller, which isn't all that uncommon even now. That means that the buyer's closing costs, they could easily be 3% of the loan amount. So if this is a $400,000 loan amount in the case of the VA option, right? They're borrowing the full purchase price, $420,000. 3% of that, like $12,600 paid by the seller for the buyer. So point there is, it's more than just price. And you need to know this contract well enough to sort through that thing and help them understand. What is this offer about? Let's don't get excited yet. Let's see what all of the terms are. Earnest money is also called good faith money. Shows the buyer serious. You guys answered that for me top of the time tonight. It is not required, and it's not an essential part of the contract, meaning it could be zero. And it's not consideration. It's not any of these things: requirement, essential element, or consideration. Here's something else about it. This earnest money, again, has to live in a trust account. So when does it have to be put in the trust account? By the person whose trust account it is, whether it's one of the firms or the closing attorney, it's got to be deposited within 3 days. Within 3 days of the receipt, of the time that that person gets it. And here's the other thing about earnest money that they like to test on. What happens if the parties don't agree who gets it because the buyer chose to walk away? Let's look at this situation. Here's our timeline. Under contract, closing date. Here's our magical due diligence deadline. What if the buyer backs out right here? They just wake up one day and says, never mind, I don't want to do it. Do they have the right to do that? Can they just change their mind for no reason? Can the buyer choose not to buy it for no reason at all? Yeah, it's worded in the contract. Buyer can back out for any reason or no reason. So they do that. They're going to lose their due diligence money. What about the earnest money? Are they going to be able to get that back? Could they maybe not get it back because of this guy? It could depend. What's it depend on? The seller would need to sign a release form. In order to terminate a contract and release the earnest money, even though it's mentioned in the contract explicitly that the buyer has the right to get the earnest money back if they back out within the due diligence period, it doesn't matter. It says so explicitly, but the seller still has to sign. If the seller says, you know what, I'm mad at that buyer. They backed out during the due diligence, but I don't care. They shouldn't have done that. I went ahead and bought a house and blah, 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 and woe is me. I'm not signing. If the seller refuses to sign it, the EMD, the earnest money release, then what? So you're the broker in charge of the firm that's holding this earnest money in the trust account. What do you do? What can you do if the seller says, I'm not signing the release? Do you say, well, I don't care. I didn't like you anyway. I like the buyer better. I'm giving it to the buyer. Give it the one you like better? No. That's your client, though. Don't you owe more fiduciary to them? You are fiduciarily responsible to them, but you are the custodian of this money. And so your first try, your first effort is probably going to be, are you sure? Come on, guys. Do you really want to make a thing out of this? Are you sure you don't want to just, I don't know, maybe not release all of it to them? Hey, buyer, would you be okay if they split it in half? The buyer might say, why would I do that? It says in the contract I should get all of it. And plus, I can't buy anything and make another offer on the next one without that money because it's $20,000 of earnest money. They kind of need it. They don't have extra 20 grand laying around, whatever it may be. So they might not agree. Ultimately, if they don't agree, you're right. That broker in charge, can turn the money over to the clerk of court. They'd give the parties another try. They'd say, hey guys, are you sure you don't want to work it out? Oh, you don't? Well, then here's your notice. In 90 days, I'm turning this over to the clerk of court in the county that this property is located, and then they will work it out with you. And if you still can't work it out, ultimately it could end up going to North Carolina. The state could absorb it. The state could get it. So it kind of goes back. I think we might have mentioned that scenario when we were talking about the 3-year term or the 3-year time period that you have to hold on to documents. You have to have the files, keep all your files for 3 years of every transaction. And so it wouldn't be until that broker in charge got rid of it out of their trust account that would start the 3-year clock on that particular transaction. Because that transaction is still kind of, it's dead, but there's still activity going on, right? So look for that on the test too. So if there's a dispute, parties would have to agree in writing. If they don't, and this could be an attorney who's holding it in their trust account, not always a broker, would deposit it with the clerk of court, who would then decide. Effective date's an important date. What is effective date? What do I mean by this thing, effective date? What sort of signatures do we have? Everybody signed. Any initials are initialed and dated. Signatures from everybody. All that's done. And those things have been communicated. Don't forget the communication. Now, hopefully the communication is on the same date as the last date mentioned on the paper, on the contract. That's the way you should do it. But they could have all been signed but not communicated that was signed for another day or 2 or 3. And so officially the effective date would be whenever that thing got communicated. It just makes it unclear and awkward if the actual contract doesn't have that actual effective date on it. So you need to line that up. So yeah, it's the official date that we're under contract is typically the intention there. The last date someone signed or initialed something, some sort of a change, and the communication that happened. Now we have an executory contract. We are under contract, and some certain dates start ticking because it might be that the due diligence deadline is on, today, March something. If we wrote a contract that went up today, March 29th, I could see a due diligence period maybe going through April 20 something, 21st, 25th, maybe about 3 weeks. That's what I would shoot for. But my question first, before I set that up and advise the buyer, I would ask the lender. I'd say, hey, lender, originator, loan officer person, how are appraisals going these days? How long is it taking for an appraisal to get done and turned back in? Because we want to make sure it appraises for the full sale price. If it doesn't, we want our buyer to have the ability to back out if they need to, if they want to, because it doesn't appraise. They might have to because then they can't get the loan, remember? The lender is only going to make the loan based on the lower of the two things, either the contract price or the appraised value. So let's make sure that buyer has complete protection to back out over whatever they want to back out over. That means we need that appraisal to get done during the due diligence period. And we need the inspections to get done during the due diligence period, and the survey, and the shopping for home insurance, and any reason they might not want to buy it needs to be handled during the due diligence so that your buyer has full protection and ability to back out if they need to. So that's huge. How much due diligence period do you need? As much as they need to do all of that research. Verification. Maybe they want their Uncle Joe from California to fly out here and look at it because it was a contractor 80 years ago. And you're like, really? Can't we just have like a real professional do it? You'd probably think that, not say it. Ooh, that's a great question. Heather says, if there is no due diligence money, is there still a due diligence period? And that's where my difficulty is with our terminology. I don't like kind of how we refer to this stuff because you're exactly right. They are independent of each other. The due diligence period can be 0 days. The due diligence money can be $0. The earnest money can be $0. And so you could have a due diligence period of time, but 0 due diligence money. So you got right down to the bottom of that. You got right to it. It could be 0 due diligence money, but still you would have the right to time. They're just independent. It's all negotiable, the fee and the period both. The money is paid directly to the seller. The due diligence money is paid directly to the seller. Make sure you got that. Let's do a little chart. Due diligence versus earnest money. Are they considered liquidated damages? Yes to both. Are they a credit to the buyer at closing? Meaning the buyer doesn't need to bring that much money. It's that much less they need to bring. Yes to both. Both of them are credits to the buyer at closing. Is it made to seller? Payable to seller? Only the due diligence money, not the earnest money. So due diligence is paid to the seller and due when? Due diligence money is due, here it is, to use a term we just covered, effective date. Due diligence money is due on the effective date. What if we just worked out the contract and got it back from the other party signed? And now we have a signed executory contract that has been communicated. And right now it's 8:27 p.m. Real world situation. We do things all hours, guys. 8:27 p.m. we get it back. We call our client, super happy. Look, guys, congratulations. We're done. We don't have to look at a million houses anymore. We are under contract. We have approximately 3.5 hours to get that due diligence money into the hands of the seller. You don't show me on camera. You don't have to prove it. But my question is, who's in your jammy jams right now? It's 8:30. You don't want to go back out there. And I don't blame you. In real life, the agents are probably going to say, look, guys, if the clients don't care, let's just get up tomorrow. Let's just connect tomorrow and I'll get you that due diligence money tomorrow. But it's in the contract right here. That the due diligence money is made payable and delivered to seller by the effective date. Let me see if I can find. There you go. Should the buyer fail to deliver either the due diligence money or the initial earnest money by their dates that they are due, and since we're talking about due diligence, that date that it is due is the effective date. Or if a check bounces, then the buyer has one banking day after written notice. Written notice from who? Who would give written notice demanding that that buyer must deliver what? Cash, official bank check, or wire to the seller? If they don't timely deliver those funds, the seller has the right to terminate upon written notice, and they're entitled to recover the due diligence money and the earnest money, even if the earnest money hasn't been collected yet. What does all that mean? It means here we are at 8:30 at night. If the seller demands the due diligence come to them on effective date, which is basically sometime in the next 3.5 hours, then they could submit in writing and say, look, I'm mad that you didn't bring it to me tonight. Therefore, now you have one banking day. I've given you written notice to give it to me because you didn't. You have 1 day to give it to me. And if you don't, then I can terminate this contract. And guess what? In a market like this, I'm happy to terminate this contract. I'll just pick one of the other 14 offers I got. You're not respecting my seller's market we're in right now, right? And the seller is entitled to recover the due diligence and the earnest money because you didn't provide the due diligence ASAP. And you're like, how are they going to get it? They're going to take them to court. Good luck. Maybe it'll work. Maybe they're an attorney and they could save on some attorney fees. But the seller, it doesn't say they keep it. It says they're entitled to recover it. The whole issue we're talking about here is that the due diligence money is not in the seller's possession yet. So this provision says the seller is entitled to go after it in court and the earnest money too. That's what the buyer is subject to. So not only is the buyer not buying this property because they didn't provide due diligence money on the effective date, but they're going to have to pay the due diligence and the earnest on top of it. And guess what? If the buyer and seller go to court over this and the seller pulls this document out and can prove that this happened the way it did, the loser pays the court fees. So insult to injury, right? Buyer's going to be out the house, out the due diligence, out the earnest money, and out the court fees. So do what you're supposed to do when you're supposed to do it. There's your advice as the broker to your client. Let's not make this difficult. But again, as long as they don't care, as long as that seller's not super OCD and ticked off about it, it's probably going to be fine that we wait till tomorrow. Let's just make sure. Let's make sure everybody's cool. Hey, seller, it's 8:30. Are you okay if I bring you that due diligence money tomorrow? And most of the time they're going to say, yeah, that's fine, whatever. But occasionally they might say, well, in matter of fact, I had this same thing happen to me. I pulled it off the market and they never paid me. I gave them a couple of days. They never brought me the money. Then they ended up backing out and I had that's the problem, guys. If you don't collect that due diligence money in time, say for like 2, 3, 4 days, then the buyer ends up backing out. The seller has no recourse. I mean, yeah, they can go pursue it if they have given written notice in this situation. But if none of that notice stuff happened, the seller's just out. They wasted time, especially if you change the status in the MLS to under contract and you lost your showings, right? You were fully expecting this to work out and you didn't, as the broker, make sure that due diligence money got to the seller in a timely fashion. That's the only thing holding the buyer's feet to the fire, right? So that's my other soapbox lesson. My first one is there is no job description except get to closing. That's when you get paid. That's when everybody gets stuff accomplished. While, of course, making sure your client's taken care of. Second thing is, this is what you're doing it for. This is what leads to that. Therefore, oh, you want to go to the ball game? Oh, you want to go to the movie? Oh, you want to go to dinner? You want to have your whatever? Cut your toenails because you do that every 2 weeks, rain or shine. Well, you've got a contract and you've got some due diligence money that needs delivering. That needs to be the priority. Don't do anything that could make this whole deal fall apart. It's a terrible way to start, right? The under contract period. Let's make sure everybody's confident that you're going to hold this thing together properly. That is the priority, right? Talk to your BIC. But for the most part, this is high priority activity. What are your choices here? You could take the due diligence money to the seller directly, drop it off. You could meet the other agent, give it to them. Sometimes agents say, let me just drop it in the mail to them. Do I have a problem with that? Mailing due diligence money? I do. How long is that going to take? There is no mailbox rule for money. You can't consider the seller has it in their possession just because it's got into the postal service. That is no such thing. The mailbox rule is only for the acceptance of offers, to count the date it hits the mail as the date that it's delivered, but not for the money. So you got to really respect the money because it's the only thing that's going to protect the seller if that buyer decides to walk. Let's protect our break. I'll see you back in 10. Welcome back. Okay. Let's come on back together. Got this poll working. Let me see. I hope I do. There we go. Are you guys seeing it? You're seeing the poll window? Okay. Let's do a little quick, doesn't have to be quick, but let's do a review of Unit 9. So I'm going to give you a few minutes. Work your way through these 10 questions. Take your time. Answer them. They are anonymous, so you don't put your name to them. Nobody knows what you answered. And then at the end, I'll share the results and we'll talk them over. So I'll be quiet, give you some time to go through those polls. Just take your time. We got a few more people left to finish up. I see about 4 more to go. So I haven't forgot about you. I'll be right back. Okay, I think we're just about done. Let me share those results with you. Okay. So an express contract is always written true or false. Express contract, is it always written? What does the word express mean? It doesn't mean how you're conveying it. It just means that you're conveying it, right? That you're saying something of what you're going to do. Not that you're making them guess what you're going to do based on your actions. That would be an implied contract. So good job. Most of you got that one. Express contract could be written or it could also be oral. Buyer and seller have both signed and dated the contract. The closing is in 30 days. This is an executed contract, true or false? Easy points, guys. Know the difference between executed and executory. The closing hasn't happened, so it is not an executed contract yet. Good job. Most of you got that one. This is an executory contract, so watch out for that. Which of the following is illegal? A unilateral contract, implied agency, a bilateral contract, or an express agreement? Got a little bit of a spread here, but most of you got that right as well. The illegal thing here is implied agency, right? Making them guess who you represent based on your actions would be implied agency, and that is not allowed. That's illegal. We got to be very intentional. We got to say who we represent, either in writing or orally, depending on the start of the situation, but we can't just make them guess it based on what they see us do. That would be implied agency. And then a unilateral contract is fine. That's not illegal. That would just be a thing where one party has made promises that must be kept and the other one has not. An example of that is the option to purchase contract. And that's a legal thing. And the option to purchase, meaning the buyer has the choice to decide to buy or not. The seller has to sit back and just wait while the seller has made a promise. I will sit and wait and give you a chance to decide later. The buyer can choose not to go through with it. That's why it's unilateral. One promise, the one made by the seller. Bilateral is an example of a contract that is pretty standard, that we've been talking about this whole time. A contract between a buyer and a seller. That's a two-party or a bilateral contract. That is certainly legal. The only thing illegal here is implied agency. Had a unanimous decision here on number 4. What makes a contract voidable if one of the parties is 16, less than 18, sane or sober? You got it. Good job. Which side can walk away from a valid contract with no consequences? Which side can walk away from a valid contract with no consequences? The buyer side or the seller side? Is that what we're talking about here? In this case, when it's a valid contract, they both have obligations. They both have consequences. Therefore, neither party can walk away without consequences. And now this might have just been difficult or unclear because of how you read it, right? You could have meant neither, but you picked either. I think one of you picked either. That either party having no consequences would be a void contract. Like either one can walk and not have any consequences. That'd be an example of a void one. Which side can walk away from a void contract without consequences? And that's either. Good job. Either versus neither. It can be confusing. Number 7 now. A 30-year-old seller agrees to sell to a 17-year-old YouTube millionaire. The buyer had inspections and asked for $12,000 in repairs, and the seller did those things. The day before closing, the buyer backs out because they decided they need an even nicer house. What are the consequences to the buyer? There are none. Most of you got that. They can walk away. It is a voidable contract because they chose to sell it to a minor. And that minor can walk away at any time with no consequences because it's voidable. And as to that first answer, buyer can be sued for specific performance. Well, first of all, they can't because of the voidable thing. And second of all, a buyer wouldn't be sued for specific performance. It would be a seller who gets sued for specific performance if they were to breach. Number 8, a seller signs a contract with a buyer who also gives $20,000 of due diligence money. The seller later finds out that the buyer has been determined by a court of law to be incapable of handling their own affairs due to mental incompetence. What kind of contract do they have? Court of law has determined the mental incompetence. Do we have a void one or a voidable one? I threw some extra stuff in there, which might have been confusing, right? I said void because there's a paperwork involved. Well, the paperwork is like the court order document, right? So if we want to say void means there's a problem with the paper, which is a good rule of thumb, or voidable means there's a problem with the people, that they're not either 18, sane, or sober. So in this case, a court of law has determined this person to be incapable of handling their affairs. That makes this contract void. Void, not voidable. I'm kind of surprised because I think most of you got that the beginning of the night tonight in the chat. So the legal determination by a judge, by a court, makes that void. But if it weren't for the judge and court situation, it would typically be a voidable contract. So just be careful about that little nuance there. That makes sense? We okay there? Looking at faces. Okay. Let me know if it's still confusing. Number 9, a buyer wants to make sure their offer is contingent on them getting FHA financing. What do they need to include with their offer? And you could answer this question and not know anything about FHA financing. All you need to know is what an amendment is compared to an addendum. And notice that we're talking about an offer instead of a contract. Because when we're adjusting an offer, making changes or, I guess, adding provisions with your offer in the beginning of the process, that would be an addendum. So good job. Most of you got that. FHA addendum. There is no such thing, by the way, as an FHA amendment. Because we need to figure out, is it FHA financing? That needs to be done at the offer phase, not while it's under contract. Number 10, which is not an essential element to a contract. A contract, does it need to have mutual assent? You bet. We need to have an offer and an acceptance. Level 3 material in this chapter, right? Mutual assent is about someone making an offer and the other person accepting or countering, and at some point an offer is made and accepted. So that is absolutely an essential element to a contract. Consideration is too. The sale price, what you're bringing of value, probably money. It could also be anything of value, but that is another essential element. And an essential element to a contract. Essential element basically means what makes it a valid contract. I could have added that word to be more clear, which is not an essential element to a valid contract. Competent parties are. So the only thing left is recordation. It's still a valid contract even if it's not recorded. And guess what? It's never recorded, right? Contracts don't get recorded. Deeds do. Deeds of trust do. We'll learn that in the finance chapter, basically the mortgage. But a contract does not get recorded. Hope that helped. It might have been even more confusing, but that's okay. Okay, good. There we go. And we'll do more of reviews, sorts of things like that to kind of help keep me from yelling at you the whole time. There we go. Okay. We were talking about the due diligence fee and the period and had a great question before we left from Heather pointing out that the money is its own thing. The period of time is its own thing. One doesn't have to exist with the other. They could be independent. You could put up no due diligence money, but still ask for time. Because all that time period is, what I don't like is that we call it due diligence money. I don't know what we should call it, but I think it's confusing because you would exactly come to that same conclusion. Oh, due diligence money is what you pay in order to get due diligence period. And that is not true. The due diligence period is the duration during which you're doing your due diligence. That means you're checking, inspecting, doing whatever you need to do as the buyer to figure out if you want to go through with this thing or not. The money is the deposit, the non-refundable deposit to the seller. But I don't like to say in exchange for the amount of time because they are not connected. Buyer can back out for any reason or no reason. They would just need to put that termination in writing. When do they need to tell the seller that they're going to back out? When does that buyer need to write it up and send it to the seller and say, I'm out of here? At what point is that required? When does the buyer or the buyer agent on behalf of the buyer tell the listing agent that the buyer doesn't want to do this anymore? Yeah, that's a good answer. As soon as possible. They could do it anytime. The question is, how much money are they willing to lose? If they want to preserve their earnest money, then they better do it, you got it, Samantha, before the due diligence period ends. That time is of the essence, date and time, 5 p.m. on the fill in the blank date. So if tomorrow is our due diligence deadline, tomorrow, Thursday, 5 p.m. At 5 p.m. and 1 second, now the buyer can still walk away. They can still leave. But then at that point, they're going to also walk away from the earnest money, right? What if the buyer has had lots of inspections done and there's lots of things wrong with the house and they've asked the seller to fix items 3, 5, 7, and 9 on the inspection report. And here we are, day before the due diligence date, 5 p.m. tomorrow is the end of due diligence, and you're the buyer agent. Tomorrow rolls around about 4 o'clock p.m. What are you going to be thinking? What are you going to be doing and talking to your buyer about? You have an hour to go. You don't have any word from the listing agent, from the seller about whether they're willing to fix those items or not. What's your conversation with your buyer client? There you go. Better be okay with them not fixing anything, because as of an hour and a second from now, if you stay in it, if your buyer doesn't give you something in writing signed that we're backing out, then they're basically saying they're going to take it as it sits. They're not going to ask it to be fixed. So what you really need to do is say, if this is important to you, buyer, then let's be ready for you to terminate this thing in an hour or sooner than. And you're going to try to reach out to that listing agent, as I'm sure you have already been trying, right? Maybe they're just sometimes they ghost you. And you're going to text and call and email and call their broker in charge and do whatever you can to say, look, we haven't heard anything. And FYI, if we don't hear back any response about, we can't work out these repairs to satisfy my buyer, then this is off the table. My buyer is terminating. By the way, what if your buyer terminates because the seller wouldn't respond and so therefore they didn't know about the repairs? Are they getting their due diligence money back? They're backing out because they couldn't get all that nailed down. They're not sure if the seller's even going to fix anything. they're running out of time. Well, that's just part of it. That's the part that's not so great. You're right. You're not getting it back. And that's what you have to explain to the client way in advance so they understand, oh, wow, due diligence money. That's some stuff right there. That's like, yikes. They need to really grasp the gravity of this thing. The seller doesn't have to fix anything. Are you going to be okay with losing that money if you choose to walk away because the seller won't fix anything? So when that buyer makes the offer, they don't have the inspection before they make the offer usually. They need to feel pretty confident that all that's going to work out, or they're going to be at least willing to walk away with no repairs being made. Because that could very easily happen in a market like this. So sometimes you just need to be ready and get that document filled out and ready to submit if they don't respond with what your buyer needs to know to decide if they're going to go through with it or not. We talked about this already. The minimum amount for due diligence money and earnest money is 0. You could have nothing. Settlement, the date called settlement is when the things get signed, right? It's when all those closing papers get signed, loan documents, and the attorney has had those clients sign those things. It's negotiable. It is not a hard date, meaning it is not a time is of the essence date. It is so not absolute that there's a built-in cushion of time, because it's quite common that closing dates or settlement dates get pushed, get delayed. Any idea the sort of thing that might delay a settlement date? That's the biggest one. You got it. The loan can do it every time. The lender is working in their own time, and the financing could certainly extend it. It could also be something to do with the seller having a problem, maybe getting things repaired in time, and the buyer insists on them being repaired. They don't want it to linger after closing, and the seller just can't get it lined up. So that closing date is a best effort. And here's the other testable thing. The amount of built-in cushion, if we have to go beyond the settlement date, sorry, I keep saying closing, beyond the settlement date agreed upon, you have a built-in 7 days that neither party can charge a penalty per day. They have to give. This doesn't mean you can automatically expect it's going to happen or assume it's going to happen. When you put in a settlement date, it should be the date you're really expecting to hit this and get this thing settled. But there is that cushion. There is an extension available if needed through no fault of the parties. Everybody's using their best efforts. But if we just need a little more time, then we can go 7 days past the time. What happens if we get to that 7th day and we still need more time? Any guesses? Seven days is built in, but what happens if we get to the 7th? We need more time to close. Essentially, something needs to be added in writing. Not a whole new contract, but yeah, you could extend it. There would be, you got it, Joseph, an amendment. It'd be, let's see, what is it called? An agreement to amend. An agreement to amend. Let's look at that. Because I think it helps you to internalize it when you can actually see it in action. Here we go. This agreement to amend accomplishes several goals. So it's not just for one thing. If we needed to change the price, maybe because of the repair negotiations, things couldn't get fixed in time, so let's just drop the price to make up for the fact that you need to do $10,000 worth of a new roof Don't worry about the roof. It's conventional loan or it's cash, so we don't need to worry about fixing the roof, but let's come off the price. By the way, lenders don't like you to make price changes through the loan process, but if you needed to, this would be the amendment that you would use for it. Changing the price from such and such to such and such, and it could go up or down depending on the need. Changing the earnest money amount, that could be affected. If there's a building deposit, like for new construction, there's a change for that. But these, I think the ones that are used the most on this form are the due diligence fee, the due diligence period, and the settlement date and expenses. So let's look at a couple of these things. Why would the due diligence fee be changed in a contract situation, do you think? What could cause someone to want to change the amount of due diligence money? How about that situation where tomorrow rolls around, 4 p.m., seller does finally respond through the listing agent and says, look, we need more time. No, wait, let me think of it. The buyer says, look, seller, I need more time to have this one more inspection done. If the buyer needs to get more due diligence period time, they can't just add to it. They've got to get the seller's permission. And the seller might say, okay, sure. What do you need? Another week? Okay, here. Great. But it's going to cost you more due diligence money. I'll give you another week for another $1,000. So adding or changing the due diligence fee is probably going to be a product of asking for more time of due diligence duration. And that explains the period one too. Maybe just buyer needs more time to get the appraisal done or inspections done or maybe a survey. But again, and they would be at the mercy of the seller, allowing them to have more time. What if the seller says, no, you've had enough time. I'm not agreeing to this. No extra time for you. What are the buyer's options if the seller refuses to give more time? It's not complicated. It's the same option the buyer's had this whole time. What's the buyer's right the whole way through? Yeah, back out for any reason or no reason. It'd just be another reason. So the buyer always has that opportunity. It just depends on if they're willing to walk away from the earnest money or not. Changing the settlement date is another option here. Notice too, if we get to that 7th day of built-in cushion, we would need to use this. And this is the whole point of bringing this up. This is where we would add to the settlement. We'd say, look, we need another 2 weeks. Let's change the settlement date to 2 weeks from tomorrow or whatever change it is. And because there's a built-in 7 days of cushion, it might be that the parties say, whoever's the one that didn't cause the delay, because it could be either side, buyer or seller, that needs the delay. So the non-delaying party could say, look, I'm giving you an extension of this settlement date, but if we get to that extended date, don't ask me for another 7 days. I'm only going to give you another 4 days of built-in cushion because of that extended closing date. So if you check the box, it limits it to 4 instead of the 7. But the original contract is all about a 7-day cushion past the settlement is kind of built in there. And then sometimes because of the repairs that are needed, instead of doing the repairs, maybe because of the interest of time, maybe it takes a while to order the windows and they're going to be 8 weeks before they come in and the closing is in 2 weeks. Well, let's just don't worry about the windows. Instead, let's let the seller pay $3,000 toward the buyer's closing costs. And we'd handle that here. with the amount the seller is going to pay toward the buyer's expenses. And it might be that we need to add a home warranty, and that's a place for that as well. So this is a very commonly used agreement or an amendment that's sort of tied in often with the repair negotiations. So we've talked about settlement date, and that relates to closing date. Hopefully they're on the same day, but sometimes not. Settlements when the papers are signed. What is closing? What makes it a closing date? There it is. Recording that deed. That's it. Recording the deed is the closing date. Hopefully that's within a couple hours of when everything was signed. But sometimes it gets delayed. The deed gets recorded, and that's when the seller can get their money. The attorney's not going to release the proceeds to the seller until that deed gets recorded. So it's pretty important. It's also officially when the buyers should get the keys, but sometimes the seller is laid back and cool about it and says, you know what, go ahead and give them the keys. It'll probably be fine. I'm sure it'll record fine. But you as the broker just need to be kind of officially on record as saying, look, guys, proper procedure, no keys until recording. But if the parties agree otherwise, fair warning, right? At your own risk. Sometimes the parties need to stay later, like maybe the situation where we were supposed to close on Friday, but the settlement happened on Friday, but it wasn't soon enough to record the deed on Friday because at 4 p.m. that Register of Deeds closes, even the online version. And so now we're not having a closing until Monday, but everybody's stuff is on trucks, right? Everybody's made commitments. Momentum is in action. And it's quite common that the buyer might say to the seller, can we go ahead and move in for these next 2 days over the weekend? And that's when you say to them as the broker, no, I'm just kidding. You say it's up to you, but here's how that works. Let's get a special miniature lease called a buyer possession before closing agreement. And it spells out things like who's responsible for HOA dues, how much will the rent for these 2 days cost, how don't forget to adjust your insurance coverage. That's the big one. That's the big testable one. Write that down. If there's a delay and either the seller's moving in before closing or the buyer's moving in before closing or the seller is going to live there after closing, like me, by the way, I have the right with this contract to buy my house to stay here for 3 months after closing because I wanted to have time to figure out where the heck I'm going and have the money in hand to do it with, right? Instead of committing to something now and then it just falls apart and then I've got a lease signed and a deposit that I'm going to lose because somehow this trunk contract doesn't work. That's a bit longer than most seller possession after closings go, but anytime that happens, now there's a tenant in the property, right? If the buyer's moving in early before we close it officially on Monday, the buyer's going to be a tenant for 2 days, a renter. They need to pay rent, and they're going to pay it as a lump sum at closing using this buyer possession before closing miniature lease, spelling out who's responsible for what and what happens if they don't leave and what are the penalties. And it's about a 2-page document. It's not super complicated. But the main thing is to remind them, look, guys, you need to get renter's insurance to cover your personal property for 2 days. And hey, seller, call the insurance company back because I know you're such a planner and a detailed person like my wife that you called them 3 weeks ago and said, look, as of Friday, which is today, cancel my policy. You need to cancel the cancel. Call them back. Say, keep the policy. Don't cancel it today. Run it through until Monday at least. Probably just keep it up and I'll let you know when to cancel it because we had a delay. You need to keep that policy there, especially if the buyer's moving in. Because if that buyer throws a celebratory bonfire and catches the house on fire, make sure that coverage is in place, right? What often tends to happen is, you're right. It would be totally up to the seller whether they're going to allow that buyer to move in early. Good question. Somebody said they don't have to let them do it if they don't want to. No, they don't. The buyer might say, great timing, by the way, Joseph. Buyer might say, well, seller might say, no, you can't move in early. The buyer will say, well, could we at least put our stuff in the garage and get it off the moving truck so we don't have to pay for 2 moves, right? Putting it in storage for a minute and then coming back and getting it and then taking it over. Again, as a broker, you're just like, well, look, guys, here are the risks. What do you want to do? And then let's make sure insurance coverage is in place. Don't cancel anything. And make sure that person who's there as a tenant has tenant coverage. What sorts of things should that buyer be looking for, and you as their buyer agent counseling them to look for during this due diligence period of time? All kinds of inspections. Sure thing. Surveys. You bet. Anything else? Inspections. I mean, what could there be? There's like a basic inspection, a general structural mechanical inspection. There's maybe that person says, looks like there's some fungal growth, maybe some mold. Looks like, do you want to have a radon inspection because it's a basement home? Yep. Thank you, Catherine. Appraisal as well. How about making repairs? Do the repairs need to be done during the due diligence period? What needs to happen during the due diligence period after all these inspections get finished? And there's several things that the buyer wants to have the seller fix. Yeah, let's get it negotiated. Let's get it written up and locked down that the seller agrees to fix 3, 5, 7, and 9 on the inspection report. That's all you need to accomplish during due diligence, and then the seller has all the way up to closing or the walkthrough before closing to do the work, to get the work done. It needs to be done in a workmanlike manner, a good and workmanlike manner. So can the seller fix it themselves? Yes, officially, but they need to do it right. Sometimes I've seen buyers, agents write it up and say, need to be done by a licensed contractor. And it's the right of the seller to fix it themselves. So they could reply, well, I'm not going to commit to that. I can do it myself, but it will be done correctly. And then what? Repairs are done some way or other. What's the buyer agent thinking next when they get word that all the repairs have been finished? What's that buyer agent going to counsel their buyer? Yeah, you bet. Let's make sure. Are you sure? And guess what? Let's not do it the morning of closing. Don't wait until the walkthrough an hour before closing to get there and realize that the seller, oops, oh, so sorry, guys. I didn't know you meant that window was broken. I thought it was the other window. Oh, well, too bad. I guess we're going to go ahead and close without it, huh? Maybe not, right? The buyer's ultimate leverage is not closing. It'd be a big pain, a big hassle for them not to close because of repair items left undone. They would probably have to push the loan would have to get resubmitted. The documents would have to be redrawn up. It might be outside of their loan rate lock. We'll talk about in finance chapter. The rate gets locked in for a certain number of days, and maybe that lock expires today. And if we push the closing past today, it's going to go up because the rates went up. You were locked in at 6.5, but now they're at 7.5. And if that closing gets delayed because the repairs weren't done, that buyer's got another thing to be mad at the seller about. And is the seller going to pay for the rate lock extension? You can pay to lock in that lower rate further, but it's going to cost extra money, right? So, best practice, as soon as you find out things are fixed, like a week before closing maybe, you get out there and make sure they're fixed. And sometimes, again, we are brokers. We're not inspectors. let's go ahead and counsel our buyer to go ahead and foot the bill and pay for a re-inspection. Maybe let's let the inspector they hired the first time come out another time and see that all the things got done to their specifications as they intended and advised. Right? We are past time. We are done. We're going to pick this up and keep in 10 tomorrow. So just keep at it. Keep going in order of the syllabus, 10, 11. 11 will be next, and we'll probably get into that tomorrow as well, but we'll still spend a good bit of time on 10 tomorrow night. Have a great night tomorrow. See you then.